Please, Your Lordship, with sincere apology, my Lord, I want
Ah.
to mention item number 25. My Lord.
Yes.
Can it be taken up some other day, my Lord? Some difficulties today, my Lord.
Okay. 2017 matter.
I understand, my Lord, but some difficulties to this, that is why.
Then it will go after view.
Yes.
Okay, on the prayer of Mr. H. Somal and Council Board of Petitioners. Now, Mr. H. Somal and Council Board of Petitioners made a prayer for adjournment. First of, you have informed the other sides.
My Lord, the other side is the government. I'll tell you.
Yes. Okay. As the prayer is made with the consent of the Learned Council for the state respondents, the prayer is allowed. So considering the as the petition is of the year 2017, list the case on after May. Second.
Obliged.
Lordship, I beg to mention item number 43.
43.
Yes, Lordship, I have communicated with my department, income tax department. They need 2 weeks time, Your Lordship, due to March financial year.
43.
Lordship.
Okay.
I have already consented to the.
Okay. Mr. B.N. Dr. B.N. Gogoi, Learned Council, Learned Standing Council, GST.
No, income tax department.
Income Tax Department. Okay. Has submitted that the necessary instructions to file counter affidavits have not yet been received, and he has thus sought posting of the case after 4 weeks. Post of the prayer for filing of counter affidavit.
Lordship.
Post of the prayer is allowed, release the case after 4 weeks.
Lordship,
Like
interim is
it
there,
by-
Lordship.
Okay, Mr.
S.
Mr.
S. K. Saha on behalf of MS.
Mr.
S. K. Saha, Lordship.
S.K. Saha, Land Council for the petition is present. Report likh lo. The interim order passed earlier. Shall continue till the next set of listing.
Deeply obliged.
May it please your lordship. My lord, I have filed this case on Thursday and I am expecting it today, but it was not listed. Can it be taken it tomorrow, my lord, for motion, my lord?
Wednesday.
My lord, from Wednesday, I will be out of station. Some urgency is there, my lord.
What kind of urgency?
My lord, one of the bank account, it is relating to DB stock consultancy. It is under freeze. Now CID is pressuring us to release some amount from the freeze amount. That is why, my lord. That is DB stock consultancy, my lord.
Okay.
Obliged, my lord.
I don't know tomorrow whether we will take up,
I will
be able
try
to
my
take up
best.
because other matters are fixed.
I will try my best, lord.
There is a division bench.
Lords.
So if the other matters are taken complete, then only we will take up.
Lordship. I am obliged.
That is subject to
Lordship.
time.
Listing on Wednesday. I'm also praying for listing.
Motion.
Wednesday, Lordship.
Motion. It will come automatically.
Eviction matter, Lordship. That's
Eviction already done or it will be done?
with us.
Okay.
Wednesday, Lordship.
May please lordship, I beg to mention item number 8. Kindly adjourn the matter for that.
Early.
Item number 8. Matter will be fixed after 1 week, lordship. From the day.
Okay. When?
After 1 week, lordship.
Okay. On the prayer of Mr.
R.A. Ahmed.
R.A. Ahmed, Learned Council Board of Petitioners. Please the case after a week.
Obliged.
Item number 12, what should allow us further 10 days time to obtain its.
Okay. Who is for a petitioner? Mr.
On behalf of
R.K. Mohanto, Learned Council for the petitioner is present. Ms. M. Deka, Learned Council representing Mr. S.C. Kyle, Standing Council GST, has made a prayer for adjournment on the ground that the necessary instructions have not yet been received. First of, and the prayer made on behalf of Mr. Kyle is allowed. Raise the case after 10 days. After 2 weeks. 2 weeks going to.
May I please, Your Lordship, I beg to mention item number 7, my lord.
Item number?
Item number 7. Matter may be adjourned for the day, my lord.
Okay. On the prayer of Mr.
N. Jaman.
N. Jaman, Council for the petitioner, the case is passed over for the day. It is submitted that consent has been taken from the land council for the respondents to make the prayer. Have you informed the other sides?
No, my lord, government is there, my lord.
So many are there. Huh? You wait then. You wait. PCB, industries, government advocate, revenue. Wait,
My lord.
wait for your time.
Please, your lordship. Lordship, I beg to mention item number 1, lordship. Lordship, here we will find a reply. If it is.
You wait, one.
Wait, please, your
Don't make
lordship.
mention of item number 1.
Wait, please, your lordship. With the consent of others, I beg to mention item number 28, your lordship.
28.
28. We need to file a reply, your lordship, in this matter.
Reply.
Reply, your
Okay,
lordship.
Mr.
As Gautam, your lordship,
As Gautam, learned counsel for the petitioner, has prayed for and is granted how much time?
1 week time, your lordship.
1 week time to file an affidavit in reply to the affidavit in opposition filed by the
Government, your lordship, revenue.
Revenue Department, respondent Revenue Department. Full stop. Huh?
Pay order is. Statement.
Okay. Miss M. Monto, junior government, Mormon, sorry. Junior government advocate for the respondent number so and so. Silable number is present. List the case after a week. The interim order passed earlier shall continue till the next list.
Oblige, your lordship.
Item 44, my lord.
44.
Want to withdraw the case, my lord, with liberty, my lord, to file it under section 227, my lord.
Mr. A. Borgotoki, learned counsel, appealing for a learned standard railway council.
Railway advocate.
Huh?
Railway advocate, my lord. Not standing counsel, no more, my lord.
Okay. Learned counsel for the petitioner. Will do. Okay. Has submitted that petitioner the petitioner wants to withdraw the petition, to avail appropriate remedy.
Actually, what had happened, my lord, the number of petitions were filed, my lord. And some of the matters came up for admission. It was found that, my lord, 226 is not maintainable, my lord, only 227. This order is also there, my lord. Almost all the matters are there except 2 or 3, my lord.
To avail appropriate remedy. To file it afresh, sorry. Petitioner wants to withdraw the writ petition preferred under Article 226 of the Constitution of India, to avail appropriate remedy. Full stop. Revenue. Mr. Revenue, Pierre Mohanto, learned standing counsel, Revenue Department for the respondent number so and so is present. Full stop. In view of the above submission made by Mr. Borgotogi, learned counsel for the petitioner, the writ petition stands dismissed on withdrawal, with the liberty as prayed for.
Much okay.
May it please, your lordship. Lordship, I beg to mention item number 6. May it be adjourned for a day.
Yes?
Item number 6.
Yes.
Adjourned for a day.
Adjourn
For the day.
for the day. Mr.
KS of the.
K. A. Sodial. Okay. Learned counsel for the petitioner has made a prayer for adjournment of the case for the day. Okay. Mr. You have informed other sides. Huh?
My lord, please.
PNRD, government, standing council, so many.
PNRD is.
You wait then 6 item, then we'll adjourn.
Please, your lordship, I beg to mention item number 15.
15,
Matter has come up in the orders column. During motion states itself.
50, 50. 50.
Yes.
Yes,
Matter has come up in the orders column, which should become up in the admission column.
so 50,
During motion state itself, the notice,
50.
service of notice has already been completed.
Mr.
Harbor.
Arbor, learned counsel for the petitioner has submitted that the respondents to whom notice says were issued on 2/12/2024, were duly represented, and as such, the writ petition is to be listed before, in the admission column. First of, registry to examine the issue and thereafter list the case after a week in the admission column, in the appropriate column.
Wait, please, your lordship. I pray for listing of a matter on 26th.
The prayer is allowed to do. Yes, 26.
Yes, your lordship.
Yes,
Lordship, there is a injunction order which was passed by the learned civil court. However, there is day-to-day violation of that injunction order by the private respondents. As such, your lordship may kindly fix this matter on 26.
why not today?
Your lordship, we have to file an additional affidavit. On
What is 26?
Wednesday.
26
It's on Wednesday.
Wednesday?
Yes, your lordship.
No.
Then on Friday, your lordship, if not possible on 26.
Go. 28, 20. 2nd of April. On the prayer of Mr.
R. Sharma.
R. Sharma, Learned Counsel for the petition, list the case on 2nd of April.
May it please your lordship. This is in regards to item number 51. I'm for the opposite party number 1 and 2. We filed the affidavit in opposition. It may be called for lordship.
If you this I will not take up. List the case before any other means without me.
Lordship.
Wait, lordship. I seek apologies. It is a fresh matter, your lordship.
Which one?
No, it is a fresh matter, your lordship. There is listing of a fresh matter.
Motion.
Yes, your lordship.
Motion matter.
Yes, your lordship.
Friday.
Much obliged.
Also, I beg to mention item number 6, my lord. In this matter, perhaps my instruction is that, my lord, I may not proceed with the matter. So adjournment for the day, I have informed the other segment, PNRD department.
Okay. On the prayer of Mr. J. Chaudhary, Learned Counsel for the petitioner. Because I have postponed it because he has said, because so many councils are
Yes,
there,
Yes.
then they will come complaining me.
Yes, ma'am.
Okay. The case is passed over for the day. It is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer.
For withdrawal, item 54.
Supplementary again. Supplementary.
May I please, Your Lordship?
Yes.
Order has been completed.
Mr. S.I. Akant, Learned Counsel for the petition, has submitted that this contempt petition was preferred, stating that there was non-compliance of the order dated 14/8/2024, passed in the writ petition WBC number 5140 of 2022. First off, he has submitted that during the pendency of the contempt petition, the order dated so and so has been complied with. First off, and in such view of the matter, the petition doesn't want to pursue the contempt petition. Mr. Dinath. Yes, for whom?
Respondent number 2.
Learned Counsel for the respondent number 2 is in attendance. In view of the above submission made by Mr. Akan, this writ petition contempt petition is closed.
So. Did this for motion? Item number 1.
Your pleasure, Lordship. Lordship, this is a matter regarding.
2021,
Lordship.
what is the issue?
Lordship, here, it is a matter regarding construction of drain over the Patta land. We are the Pattadas and owners of the land. And tried to demolish the structure. Lordship. Here, other side, respondent number 3 has filed affidavit in opposition.
One
We
minute.
intend to file the reply, Lordship. We pay for some time to file the.
For 3 years, you have not filed any reply. Why should we give you
Lordship,
time?
Sometime because we need.
No, no, let us examine first. 2021, no, at the motion stage.
We try to reach Lordship, let us reason, take proper instructions, and after that we will find a reply, Lordship. We prefer some time, Lordship, for it. 1 week time for it.
No, no, we are closing it. You go to the civil court.
Lordship.
The report is already there for last 3 years. Last 3 years report was already there in existence. After this court ordered joint verification, right?
Lordship.
It is found that no patta land of the petitioner has been encroached.
Lordship, for the, we try to, we'll find a reply, Lordship.
You come at 2, we'll decide.
Lordship.
Some dispute, you go to the civil court. It is, after verification, it is not possible. This kind of stay is operating, right?
Lordship.
No, cannot be.
Lordship.
You go through it, we'll decide. 3 years, no affidavit reply to the joint verification report. And joint verification report was carried out in your presence. And after that, no land of the petitioner was found to be encroached. An interim order is still operating.
Lordship, yes.
And road is not yet, road is stalled, construction of the road. No, 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 no. You come at 2, we'll
Yes.
decide. We'll decide. And this is now disputed question of fact. If you want to dispute, you go to the civil court. We are not here to mark your land.
Lordship.
I am clear.
Item number 2.
May I please, your lordship may kindly pass over for time being. Much obliged.
Item 3.
Lord,
Yes.
kindly give me 1 week's.
Why give me time? Give you time, 2024. Read petition. Everything is clear.
There was some lapses on the following up.
Hmm?
The following of the matter, there was some lapses on the part of the bills.
He deposited a premium.
Already, madam.
What more?
Yes, my lord, just 1 week time.
No, this is pending since
Today
2024.
also I have, today also.
Documents are clear, almost everything, nothing is to be done. You have to do your own act, correct the records, that's all,
Correct, my lord.
right? Highest authority has passed the award,
Yes.
Huh?
Yes. Joint
order,
Secretary-
subordinate authority is not carrying out.
Joint Secretary has written out.
Huh?
Only updated for his information.
Friday,
Obliged, madam.
heard Mr. J. Sharma, learned counsel for the petitioner, and Mr. S.R. Rabha, learned standing counsel BTC. For the respondent number,
All respond.
for all the
Yes,
respondents.
all the
No,
respondents.
no.
All the respond.
Or 2 to 4, first of.
2 to 4.
Also heard Mr. P.R. Mohanto, learned standing counsel revenue department for the respondent number 1. First of. Mr. Rabha, learned standing counsel BTC has submitted that has sought posting of the case on Friday as a for obtaining instruction. Regarding the region as to why the necessary corrections in the land records have not yet been made in terms of the letter by the circular, by the respondent number 4, in terms of the direction made in the office letter number so and so page 13 dated 8/4/2022 issued by the respondent number 2. Full stop. The procedural is the case of file. There is nothing.
Nothing.
Item 4.
The bank fraud matter, Your Honor. Bank fraud matter.
Bank fraud matter.
Yes, but I'm not sure if Your Honor is going to take it up because on another occasion,
Okay, list the case before any other events we do.
much obliged.
Item number 5.
Mr. Lords,
Yes.
the petitioners, they are all qualified by the pharmacists. They have passed their examinations. Then they applied for registration their name to be eligible for practice, private practice in pharmacy. My lord, the learned government advocate on that day said that the 6 numbers of representative from the practicing pharmacy council could not
Already this is disposed of. Repetition.
read
This is contempt.
Yes, my lord.
Okay.
So, my lord, Honorable High Court has gone into the greater canvas of the matter. Then, when the government has said that 6 persons were to be represented from the practicing pharmacy association has not supplied their name, and in that way, my lord, about 8 months has gone.
Okay. What is the operative part?
Operative part, my lord, then 2 parts, my lord. One, the Honorable High Court says that explaining the different provisions, particularly Section 19, says that you constitute a interim council, some pharmacy councils, because it has some public duty to do. So you cannot you cannot keep it pending like that. So that part has been implemented by the government. Next, my lord, your lordship will go to page 25,
Yes.
because this is the case started on our application.
So applications or petitioners should be given due consideration.
Yes.
That part is not there.
That part.
Okay.
So
Heard Mr. A.C. Buranghoy, Senior Counsel, assisted by Miss A. Devi, Learned Counsel for the petitioners.
yeah, number
Full stop.
let me deploy it.
The instant contempt petition is preferred, stating that the direction given in paragraph 8 of an order dated, judgment and order dated 5/12/2023 in writ petition WBC number 5564 of 2023, preferred by these petitioners themselves, has not yet been complied with. Full stop. Mr. Buranghoy, Learned Senior Counsel appearing for the petitioners, has submitted that the court had directed that the applications of the petitioner should be given its due consideration. Application submitted by the petitioner for registration. For the registration as pharmacist.
As pharmacist in
Pharmacist.
The, that is called first register.
Okay, registration
Hmm.
As pharmacist should be given due consideration. First up, it is submitted that whether this order has been brought to the notice.
Yes, my lord.
Huh?
We have brought it to the notice.
Have you annexed anything?
We have averted it, my lord, in paragraph.
Okay,
My lord.
paragraph.
Uh,
Okay, it is stated that it is averred that the order judgment and or copy of the judgment and order dated so and so has been duly brought to the notice of the respondent number.
1 and the rest also, my lord.
Okay,
By
to
separate-
the respondents
My lord.
thereafter. they will be brought to the notice of the respondents. First of, issue notice returnable in 4 weeks. The petitioner shall take steps for service of notice upon the respondent. How many respondents? Upon the respondents
4 number.
by registered post with AD
My lord.
within 2 working days from today.
Oblige. Item number 7.
Yes, we have, you have made a prayer for adjournment.
Yes, my lord.
Respond number 2.
Okay. Mr.
Anjaman.
Anjaman, Learned Counsel Board of Petitioners has made a prayer for adjournment post of Ms. P.R. Mohanto. Standing Counsel Revenue Department for the respondent number 1, Mr. R. Kolita. N. Kolita. Learned Counsel representing Mr. A. Kolita, Standing Counsel Industries and Commerce Department for the respondent number 2, M. S. Kaur, Ms. S. Kaur, Junior Government Advocate, 2, 3, 4, 5, 6, 8, and 10, and Mr. Miss B. Deka, B. Datta, D. Datta. Okay, representing Mr. S. Borwal and Standing Counsel PCBA for the respondent number 7 and 9 are present. The prayer for adjournment is allowed. How much?
1 week, my lord.
Okay, 1 week, 1 week, for 1 week allowed. This is the case. Okay. You are supposed to file some additional affidavit.
Yes, my lord. We have
Huh?
filed this, my lord, but unfortunately, our brief has been misplaced, my lord.
Okay. Place the case after we're gonna date to be fixed by the office.
Oblige.
Item number 9.
Yes, Mr. Ribwe, what is the case about?
The delimitation matter.
I'm not very satisfied with the pleadings. Not a case made out. What he wants to show? All jumbled up.
So many prayers.
So many prayers, so many things stated. I could not make out how the things are falling into places.
Perhaps my friend can explain.
But your friend is absent. There is no representation on behalf of the petitioner today on call. Mr. Who is there for Panchayat? Miss B. Thapa. Learned Counsel representing Mr. K. Kaur. Additional Advocate General for the respondent number
1, 3, and
1, 3, and 4, and Mr. R. Dubey, and Standing Counsel, Assam State Election Commission. For respondent number 2 are present in view of non-representation on behalf of the petitioners today on call. Let the case be listed after we connect it to the by the office.
Item 10.
May I please? As per order, my lord.
We directed to take exception in this matter. We had communicated, but there is no response, but just now, we tried to contact him over phone, just now we got the phone call. That he's actually, he's sending a circular.
Sending? Yes? I'm not. The subject grant of notices has been illustrated plot of line. As in 9 big as.
You see it's a function.
Some hearing was scheduled on 1st of March, 2025. And the petitioner was directed to place all the relevant documents, power of attorney. Mr. Borthakur said that he submitted all those documents. So, outcome of the hearing. So,
He's sending.
sending.
Just okay.
Okay, find out. I'll take up after some time. If it is done, then close. If it is not done, if it's sending by what? WhatsApp? Find out. If it is done, then close.
Can it be on day after?
Because all this, I don't know how the Panchayat matters will roll out. Will go to Wednesday also. That is why I am.
It's just 1 minute if I get the information.
Ah.
Can it be on day after tomorrow because?
Okay, Mr. D. Gogoi,
Lordship.
Learned Counsel for the petitioners is present. Okay. On the prayer of Mr. B. J. Talder, Learned Senior Counsel, preparing for the state respondents. Place the case on Wednesday.
Hello.
Item number 11.
Hello, item 11, my lord, the machine, no difficulty, my lord. I pay for passport for a day. On Friday, lordship, if possible.
How many? Will issue notice only. We do not want to keep this for long. This is the third adjournment prayer.
Then notice me, wish.
Third, Mr. D. Gogoi. We try to expedite, but if you go on postponing, then case will be listed only in motion column. Yes, did you got?
I have said,
Yes, let us see.
Lordship. Are you reading?
If no case is made out,
Yes, it cannot be because. Lordship, that's after. The instruction next page is sketch map pillar.
whether the land in question is within the finance that it is.
Second page below the alignment. Very distinctive. Very negative. Lordship. First page, that is 6,000. Tag number also is given.
Tag number?
228,229 Miller. That is more particularly it will go by second page, my lord. 6,000, your lordship will get. We have put some cross mark. Second sketch map of second page.
Second.
Second page. Sketch. We have
Cross.
like cross type. This is a fully edition under petition. Nowhere it is in the diverted order. This is same loop. Get all the profits may go. They take the makers in regarding compensation and thing they want. Otherwise, they cannot be changed.
It is part of the notification already, 3D. Tag number 228 and 229.
229 Miller.
It is their case, 228, 229?
Yes, that is the 228.
228, 229 is their case. And you say that 228 and 229 are under notification.
My lord, lordship stated may get it. Page 88
88.
of writ petition. It is a writ. It is
228 and 229, where it is?
it is 3. This actually that is they will get it 3. That is 3A, my lord. Again, I will take back to 3D. I will take now. That is
Yes, page 88, right?
yes, that is
Serial number 28 and 29.
228.
Non-agriculture potit and non-agriculture graveyard.
And that
Yes. Deposit 50 crore, I will direct them.
50 will be less, my lord.
50 place, 100 crore.
Because 50 10 years back, 1 kilometer, 100 crore.
100 crore.
That
Okay.
time.
100
years
crore.
back.
I'll direct them to realign the national highway. Yes. Central government, right? People are thinking of moving their car at 150 kilometer per hour. Now if there will be a diversion, there will be huge cost for everybody. And they are the experts. We are not experts. Law is settled. Call Mr. Botago.
Maybe
What? If you go, do you have 3G notification is already there, 228, 229 is there. Why should we enter into all this?
that maybe.
And why is that Supreme Court judgment?
That is, my judgment is there, I think.
If I remember correctly, para 24.
Kushala Shetty case,
Ah,
thereafter it appeal has come. That petition has, against Supreme Court order has come that basis of that. I'll go explain that also. This is,
Is it para 24?
this one is.
Let us read para 24.
Yes. 20.
24?
No, actually 28.
28, okay.
28.
Read.
I did. Para 28, that is Kushala Shetty's case. Reported by them. Anyhow, that is 2011-12, 16 Here, it will be apposite to mention that NSA is a professionally managed institutional body having expertise in the field of development and maintenance of national highways. The projects involving construction of new highways and widening of or development of existing highways which are vital for the development of infrastructure in the country are entrusted to experts in the field of highways. It compromises of persons having has knowledge and expertise in the field of highway development maintenance. NSA prepares and implements projects relating to development and maintenance of national highways after thorough study of experts in the different fields. Detailed project reports are prepared keeping in view of the relative factors including intensity of heavy vehicular traffic and larger public interest. Now this court. The courts are not at all equipped to decide upon the viability and feasibility of the particular projects and whether the particular alignment would subserves the larger public interest. That is the basis of Date Miller, his judgment has 22 judgment.
What is the citation? Next 22 judgment, 2022.
Yes, here also is there. Another question. Right. Here, my lord, it is life law. 2202.
INSC, any INSC?
Then what you get it is.
Second upload.
Since he has placed the instruction, you go through the instruction. Since he has, because you are litigating, but still I'm not. Go through the instruction. If you want to, have a look.
May take up second.
Hello.
I don't know about 13.
Oh, yeah, go to the boundary issue there. It's a whom I told you.
Wait, please, your last.
Yes,
I ordered.
that instruction.
Yes, sir.
Okay.
Sorry, I give it to.
But I thought that I got confused.
Yes.
Yeah.
Revenue related techniques, my lord, before revenue and just as well as. Department.
So according to this, now the appellate authority is Revenue and Disaster Management Department. Why is the notification composite cell? Yes,
My lord.
there is a dispute regarding the plot of land.
Yes, yes, part of the.
Yes. Where is that impugn order?
Lordship will find. My lord. Sorry.
Now the next question is whether this order is sustainable. Right to Public Services Act. And that composite cell transfer. Where is the notification composite? Mr.
My lord, it's page 58, my lord,
Page
58.
58. Page 59,
Lordship.
clause 5.
Yes, Lordship.
Circle officer, based on hearing report, consent of the cooperator, forwards the application to the additional deputy commissioner for further processing. Circle officer, based on the conducted hearing, can also reject the application or revert to the applicant for any clarification.
So there is.
Then 6, the ADC will verify the application, can see LM and CO's report. ADC can also raise objection on the application to CO. ADC will then forward to the deputy commissioner for final approval. The approved NOC will be generated automatically, be submitted composite evidence supporting document download the evidence. DC has the right to reject any application forwarded to him.
Yes, my lord. But my lord, my case is, my lord, without hearing, my lord. No opportunity has been given to me.
Where is that? Your
My lord,
reject.
Lordship may
Charge
kindly
detail.
see-
Application is rejected by ADC.
Yes, page 47.
Rejected as per recommendation of CEO as there is dispute regarding the land. Okay, page 47. Right. Now, is there any system of recording anything in any record other than this? Because this is an appellate order. Right. And as per recommendation of the CO, circle officer, ADC has rejected it. Now, if he wants to prefer an appeal, right, what he will prefer?
The rejection order, my lord.
Huh?
So the rejection order, my
A
lord.
rejection order which records reasons. This is a blank order. Application is rejected by ADC on the recommendation of the CO, as there is a dispute regarding the land. What kind of dispute? What is the nature of the dispute? To prefer an appeal, to prepare a ground of appeal, he needs the order. With this kind of order, can he prefer an appeal? And what the appellate authority will examine? Have you
Yes,
understood?
that information might.
There has to be some provision in the whatever there that to record regions, detailed regions. It is a non-speaking order. And it is an appellate order. It is an order from where an appeal lies. So what he will do while preparing an appeal before the Revenue and Disaster Management Department? This is the line. The application rejected by ADC, hence this is my appeal. One line appeal can be preferred, but he cannot justify that the grounds on which the ADC has rejected his application. What do you do if a judgment is rendered by a trial court? You prepare a memo of appeal, and what are the grounds of appeal? You have to first you have to know about this, the regions for which the application was rejected or your case was rejected. Thereafter, to prepare an appeal, you have to take out the grounds from the judgment or order, where the regions are assigned by the subordinate authority or subordinate court or district court, right? No, there is nothing. Tell me, if you, I am giving you the task to prepare a memo of appeal against this order. What are the grounds you would prepare?
Rejection order, my lord. I have to take out the certified copy of that all rejection order, my lord. I have to take out the certified copy of all rejection.
Right, and this is the order only. This page 47, one line. So, tell me, what are the 5 grounds of appeal you could prepare from this order?
Is there any provision written to the, my lord, any some rejection order, my lord, that my friend will take the instruction, my lord?
Is, madam, have you understood? Large numbers of applications are rejected with this kind of order. And it is an order which is appealable. So this kind of region, okay, this is the way to inform that whether your application was granted or rejected. But there has to be a provision for recording regions if the application is rejected, at least. So is there any system? I'm giving you till Thursday's time. Otherwise, we are handling this kind of writ petition every time, at least every day 2, 3. Is it not? You do it manually, but there should be a provision that he should record his regions, at least in briefly, that this is the dispute raised by one so-and-so, and these are the regions, so that is why the application is rejected. So he must know that why circle officer has recommended for rejection and why there is a dispute about the subject plot. He should know so that he can prefer an appeal that these grounds are not justified. This is the problem I'm seeing here. That is what you suggest. Otherwise, I'll go on doing it. There should be some additional window.
Having this rejection, he could have that original order.
Detail. And what is the recommendation of the circle officer? All this he could get so that he can prefer the appeal. We'll observe, you come out with instruction. Then we'll decide. Right? And all these are click of buttons actually. For the computer expert to open a window, for the designated public service They will record however, 5 lines, 10 lines, whatever it is. Since they have applied their mind, they can definitely record the reasons. It will hardly take 10 minutes for them.
Pass the order, my lord, it will be easier, my lord.
Yes, that is why.
This way, other day I opt for judicial notice on this particular.
Yes.
Can take up on.
Heard Mr. Ziuddin, learned counsel for the petitioner. We'll put it on all of them on notice. Right. And we'll decide on the next date.
Yes.
Now, counsel for the petitioner, P.R. Mohanto, learned standing counsel, revenue and disaster management department. For the respondent number 1, and M.S. M. Borman, junior government advocate Assam, for the respondent number 2, 3, and 4. First up, Ms. Mohanto, learned standing counsel, revenue department has submitted that after abolition of the office of the Commissioner of Divisions, who was earlier next up on 9. Next up on. Oh. No, ইয়াত ঠিক কৰিছিল না উলিয়াই দিলো সেইদিনাখন উলিয়াই দিছিলে তাই who was the appellate authority in case of rejection of an application for the notified public service, quote unquote, composite land sale transfer under the Assam Right to Public Services Act, 2012, the Revenue and Disaster Management Department has been made the appellate authority in case of such appeals, vide a notification dated 16/11/2023 issued by the General Administration Department, Government of Assam. Para. The rejection of the petitioner's application for the notified public service composite land sale transfer is also assailed on the ground that the order dated 15/7/2024, right?
Yes, madam.
By which the application has been rejected is a non-speaking one, whereas main এখন ক'ত আছে? Whereas the designated public service servant if he rejects an application seeking notified public service, is obligated under Section 7 of the Assam Right to Public Services Act, 2012, as amended, to record the regions in writing and communicate to the persons making the application. Roman 1, the regions for such rejection. Roman 2, the period within which an appeal against such rejection may be preferred. And 3, the particulars of the appellate authority. First of all, but having perused the contents of the order dated, where is that impugn order?
47 on the page.
15/7/2024. No, the contents of the order dated, rejection order dated 15/7/2024 are produced. Full stop. তার আগত একদম প্ৰথমতে দিব issue notice returnable on 3rd of April or 8th of April. 8th of April. I know the result is answer will be no. As so and so has appeared, accepted notice. Huh? Extra copies by tomorrow. তাৰপিছত এইখিনি লিখিব peruse the তাৰপিছত লিখিলে peruse the contents of the so and so. Miss Bormon, junior government advocate, shall obtain instructions from the respondent number 2, 3, and 4 on the issue. Obtain instruction. Definite instructions from the respondent number 2, 3, and 4. Whether the regions recorded in the order dated 15/7/2024. No, whether apart from the rejection order uploaded in the portal, the designated public servant records his reasons for rejection while denying the notified public service in any other record contemporaneously maintained for apprising the applicant to prefer an appeal if the applicant so prefers. First of it is the respondents, learned counsel for the respondents shall place definite instructions on the next of listing. Post of it is observed that in the event no instructions are placed, the repetition will be considered on the basis of the materials on record.
My lord, so far respondent number 5, my lord. I have made party.
Who is he?
My lord, she filed the objection, man.
Huh?
She filed the objection, man. On the basis of that,
having regard to the issue raised in this petition, this court is of the considered view that notice to the respondent number 5 at this stage appears is not necessary. Right. Because she will be given the opportunity to participate in case of appeal.
Item number 14.
Yes.
Yes, what is your instruction?
Wrong instruction, Lordship.
Hmm?
Wrong
No instruction. Tell me, yes or no?
There is no, as per the new notification, Lordship, there is no system of handover of the hard copy of the deed, Lordship. Paragraph 4, Lordship.
I'm not understanding, but oh. With effect from source. What is NZDRS?
Lord, National Generic Document Registration System.
So how do you read this proviso? Page 13.
Yes, my lord. However, the existing document registration in NDGR will be available for the citizens who have booked slots and processed for registration prior to 15 to 25, my lord.
So earlier to this,
I-
what was the procedure?
Milord, the hard copy was provided.
Do you have any notification?
That system was going on. Right now, I do not have, but the system was going on. If I get registered, hard copy is provided to me.
So what is existing system? That is the issue. Existing system of NGD, National Generic.
Document registration system.
National Generic
Document registration
Ah.
system.
National Generic Document Registration. So what is the meaning of existing, madam? In this notification, existing document registration in NGDRS will be available for the citizens who have booked slots and processed for registration prior to 15/2/2025. We know it is rolled out with effect from 31st January 2025, right? Now the second part of this notification, however, the existing document registration in NGDRS will be available for the citizens who have booked slots and processed for registration prior to 15/2/2025, exactly time 11:59 p.m. What does it mean? Existing document registration. So this has been rolled out from 31st January, but there is a provision, and that is not answered.
According to them, Lordship, they had applied before 31st or 31st/1/2025, Lordship.
Right. After 35, it is rolled out. But what is the meaning of this sentence then? Madam, your department, you get the clarification of this part of this notification. What is the existing document registration? That will be up to available up to 15 February. And he is saying existing means the hard copy. You should not have put this part in the notification then. I think Deputy Commissioner is not addressing that issue.
Before 31st.
Existing document registration. I think sale deed is also document. No, 15 February. Please see. Please see and try to understand. There is no doubt about first part. But by this proviso, you have made two options available to the parties who submitted documents for registration up to 15 February 2025. That is my understanding, subject to the understanding of Principal Secretary to Government of Assam, Revenue. And why he has put this? If he did not put it, Mr. Sahu would not have been here. Have you understood? So you take your instruction. Shall I put it on the order? Okay, heard Mr. S. Sahul and Counsel for the Petitioners, Ms. P.R. Mohantal and Standing Counsel, Revenue and Disaster Management Department for the respond number 1 and MS Cole and Junior Government Advocate Assam for the respond number 2 and 3. Full stop. Ms. Kaur, Junior Government Advocate has submitted that she has received instructions, in deference to the order dated 17/3/2025, from the District Commissioner TH-pur, Sunitpur, provide office letter number so and so, dated 21/3/2025, and has placed the office letter along with the parawise comments thereto before the court for perusal. Post. As the notification dated 30/01/2025 has been issued by the Revenue and Disaster Management within bracket Registration Department, Ms. Mohanto, Standing Counsel, Revenue Department, shall obtain instructions as regards the following parts of the notification. Page 13 or pencil to pencil. However, process 11:59 PM. only. Okay. As Ms. Mohanto has sought posting of the case on 4th of April, lays the case accordingly on 4th of April. The office letter copy of the office letter number so and so, dated 21/3/2025 of the District Commissioner Sunitpur, is kept with the case record. Right? You have a copy?
May I get a copy of that instruction?
Have a look. Yes, next.
Oblige. Item number 15.
May I please? We are a group of students, my lord, who have successfully cleared our exams, my lord, and required percentage we have obtained, my lord, and to be eligible for Dr. Banikanta Kakoti Award, my lord. Initially, the merit.
Yes, madam, this is bench by matter. Bench
Appropriate.
education. Mr. A.S. Tapadar, Learned Counsel for the petitioners. Anybody standing counsel? Okay. And Miss P.R. Mohanto, Standing Counsel, Higher Education Department for the respondent number 1, 2, 3. Have submitted that the subject matter of this petition pertains to bench 2. Bench 2? Okay. The registry to examine the aspect and thereafter lays the case before the appropriate parents in the motion column.
I'm deeply obliged.
Item 16.
May I please? Not in this case, on being threatened of Milord by
You want warrant of arrest?
Milord.
Huh?
Milord.
Whether any action has been taken on his application or not. Ms. Kaur, you have prepared an application
Milord.
seeking arrest of those.
Milord.
Huh? Where is your application?
Yes, page number 56, Milord.
Page 56. Executive Magistrate, Kamrup.
Milord.
Yes. You want to see them behind the bars?
Yes, Milord.
Okay.
Milord, I'm not at that, at least Milord, that they should execute the board, Milord. That was my limited prayer.
Yes.
But that was not.
Get the instruction from respondent number 2, whether he has considered this. We are not here whether he would issue or not. He has to act upon this application.
My lord.
That page 56. But you have not made the executive magistrate a party?
Yes, Milord, I have met.
Oh.
Number 2, Milord.
No.
Because, Milord.
Who has passed the order?
Of course, that is the executive magistrate.
Then make proper amended cost title.
My lord.
Mr.
Ali.
Ali, Learned Counsel for the petition has sought posting of the case on another date in order to file a amended cost title in terms of notification so and so, so and so. Post of MSS Court and Junior Government Advocate Assam for the state respondents is in attendance. Post of the press made by Mr. So and so is allowed. Place the case immediately after filing of the amended cost title.
Smile. I'm obliged.
Item number 17.
Did you make any application for demarcation?
Yes, Lordship.
Ah,
Uh,
what is the mode of preferring such an application? Yes. Now Miss Mohanto and Miss Bormon have gone to the digital age. You are still in manual. Is it online mandatory? It is a service already ordered by the coordinate bands. Prefer an application under Assam Right to Public Services Act in terms of office memorandum dated 27/12/2020. Where is that office demarcation sound?
it is part of my.
Let us see.
on
Very illegible.
Page, no, on
Huh?
page number 9, Lordship, type copy is there.
Type, I'll see the original one. Nowadays, I have stopped believing in type copies.
Lordship.
Demarcation. Say. I do. It is not specifically mentioned in this notification. Yes, madam. Whether manual application is permitted, otherwise you are making submissions in other notified services that online application. Right, that is why this is of 2020. And you are saying all the time that we have moved to digital system. Yes, madam. Can you take the instruction whether this still holds the fields that standard application form is permitted, then we can dispose of. But if it is not,
It is submitted on 10/11/23, Lordship.
I understand. Can you give the instruction any time today? Online or manual? If manual is permitted online, if online, since when? Have you understood? Because this code directed on 3/5/2023 that you take on valid notification. 27, okay. 27 political. If it is online, they have shifted to online in May 2023, then he has to make an application online. Or otherwise, we have to consider this part and dispose of the repetition.
And in fact, Lordship, one thing
Let
is
them,
that-
let them have the opportunity.
Lordship.
You have made out your case.
Lordship.
They have received.
Lordship.
When did they receive?
10/11/23.
10,
10/11/23.
10, 11.
The official seal is there also.
Number was also there.
Yes, Lordship.
Madam, when can? Today possible or not possible? Please tell me. Okay. You try to get the information whether in May 2025, the permission to or the system was receipt of manual application in standard format. Right? Or if by some notification already that online application is made mandatory, then he has to make the application online. But if it was permitted in May 2022 to make an application manually, then we have to proceed. Yes, after some time. Try to get it.
Item number 18.
May please, Your Lordship. The matter relates to the denial of the compensation.
No, tell me when 3A notification was issued.
A notification was issued, my lord, in
Tell me.
2020.
2020. And but this is they are controverting it.
They said that from drone we have seen, drone videography, there is no.
Then you establish your case.
That says that we have made a submission to the additional deputy commissioner who is authority.
No, you establish before a civil court.
Under Mala project, my lord.
No.
My lord,
They are denying from the very document page 33.
yes.
They have clearly denied.
But I have also given a photograph that it is an existence.
You establish. We are not here to appreciate all this evidence. That's why Maqbul Ali to Asani sound. When a fact is not denied, then it can be decided in a repetition. But for land acquisition,
my
they
landlord,
are clearly saying.
my landlord from whom I have taken the tenancy.
Mister, I can understand, I can visualize every possible situation. But this is a situation where we cannot enter into. Because NHIDCL is clearly denying that there was no structure in existence,
Well, the,
nursery in existence. Now, that
I
is what they said.
I requested them, you go and come and verify physically.
You go to the civil court.
His photograph is
Maqbul Ali
of
Sahab.
24.
Hmm?
Here's the next photograph of 24.
Yes, 24. You have taken, you have,
After that, Lordship.
We are not here, sir. 23, 24, we are not into forensic examination. You establish everything. Because you have not made out any privacy case.
but it is a fact that there is an.
Fact will be established. Disputed questions of fact, not facts. Not established facts. You go, lead your evidence, establish, get as much the compensation which
Well,
is
they-
just and proper.
They'll take away forcefully the land. They're asking me to vacate the land.
No, you have all the evidence.
They are asking me to vacate the land immediately. But if I vacate the land, my evidence will
Get
go.
the injunction order from the civil court. This is not a case. We don't find.
I leave it to Lordship.
Some cases are to be decided at the very beginning. This is clearly stand. They will again come up after 1 year, same stand. No point keeping it pending. Because this disputed questions of fact would call for consideration.
Deputy Commissioner can easily help us in this matter, madam. Because I have made an application time and again before.
Let us see. Yes, Mr. Talway, get your instruction regarding this.
Lordship.
Within a week, we'll decide in the motion stage itself.
Our instruction is clear in page 33, Lordship.
Ah.
It was, Lordship, recorded on 23rd March 2023, Lordship, after 3, Lordship. That's second paragraph, Lordship, page 33, Lordship.
Do you have the 3A notification with you?
No, madam.
Get the 3A notification, that's all. 3A notification, then we'll see the date of the 3A. We'll peruse that and we'll peruse this stand, then we'll decide. Right? When can you get it?
Next week.
Okay. Heard Mr. S.C. Viswas, learned counsel for the petitioner, and Mr. R.K. Talukdar, standing counsel NHIDCL for the respond number
4 and 5.
4 and 5. Also heard Ms. P.R. Mohanto, standing counsel Revenue Department for the respond number 1, and Ms. M. Bormon, Learned Junior Government Advocate Assam for response number 2 and 3. Full stop. Mr. Taludar has submitted that he will produce a copy of the relevant notification issued under Section 3 of the National Highways Act. Full stop. And to produce the same, he has sought for listing of the case after a week. Full stop. List the case accordingly on so and so next Monday. Next Monday. Video. It will be next.
Item number 19.
May I please? Your Lordship,
Yes.
In this petition, I seek direction for release of the compensation, my lord,
Hmm.
for acquired land, my lord. As my lord, in respect of DAG number 570, my lord, there is no other claimant, my lord. And in respect of DAG number 571, my lord, there is a title suit pending, my lord.
This is under what act? This
Lordship,
acquisition is under what act?
Assam Mala project. my
Assam
lord.
Mala is under what act?
Lordship,
Hmm? What act? National Highways Act or that 2013 Act? In that case, who is the land acquisition officer?
Deputy Commissioner.
District Commissioner. Then he can dispose of this representation,
Yes, my lord. Yes, my lord.
right?
Yes, ma'am.
By speaking order, whether he is entitled for the compensation for the plot of land where he claims that there is no dispute.
Yes, ma'am. In respect of 571, my lord, there is a dispute, my lord.
Where there is no dispute,
Yes, ma'am.
you are claiming that there is no dispute in respect of that some particular plot of land,
Yes, my lord.
and you have submitted already a representation.
Yes, my lord.
Let him dispose of.
Representation page 28, my lord.
Heard
HL Ashraman.
Mr. H.L. Oscar,
HL Ashraman.
learned counsel for the petitioner. And, sorry. Miss P.R. Mohanto. Why then you respond number 3, you have made additional deputy commissioner within bracket LA? Huh?
Additional district commissioner.
Why you have made him additional deputy commissioner within bracket LA?
Lordship, he issued the 20, kindly see the 26.
Any other document?
Yes, my lord, 26, my lord, page
Huh?
20, page 26 may be seen, my lord. He issued this notice, my lord. Sorry.
This miscase is for what?
There is a other claimant, my lord, in respect of DAG number 571, my lord.
Where is the name of the project? Any document?
Name of the project.
Do you have any document?
No, my lord, I have no any document.
Huh?
I have no any document, my lord. This is for widening of Hailakandi.
Any paper publication?
No, my lord.
Huh?
No, my lord.
Paper publication must have been made.
There is no paper publication, my lord.
How can it be? No land acquisition is possible without paper publication. Absolutely no land acquisition proceeding can be initiated without paper publication.
There is no.
Because question is that you have submitted a representation before the district commissioner,
Yes, my lord.
but I am not sure whether he is a land acquisition officer under 2013 Act. Madam, if CPS 26, that is additional deputy commissioner within bracket LA, that is a problem. he is issuing notice. If he is designated as the LA, land acquisition officer, then deputy commissioner cannot dispose of this representation. There is a specific power under the act.
On behalf of the district commissioner, maybe my lord.
No. That is not the way.
Office of the, in the.
That is not the way. He is designated as land acquisition officer.
Yes, ma'am.
Asamala, my lord, it is done by way of negotiation. So probably a notice has been issued to the interested parties as scheduled in Form B and C, so far as I remember, my lord, without notifying us special land acquisition officer. Probably DC has to delegate the power to.
No, I have seen Asamala project,
That notification.
but proceedings are undertaken under various acts.
Yes.
LA Act to this RF City, LAR Act 2013, or National Highway Act, or direct purchase also.
There is, so far as I remember, my lord, there is no such notified land acquisition officer to that extent, because it is on the basis of negotiation, my lord.
Okay.
So pre-notice is sent to the interested persons, my lord, as per Form B and C, my lord. If they agree, then only final award comes.
And Ms. P.R. Mohanto, Standing Council Revenue and Disaster Management Department for the respondent number 1. Ms. M. Borman, Junior Government Advocate, Assam, for the respondent number 2 and 3. In view of the limited nature of grievance raised in this petition, and as agreed to by the Learned Council for the parties, and considering the fact that the this petition is taken up for disposal at the motion stage itself. Full stop. Para. The petitioner has claimed that he is the owner of 2 plots of land situated at village.
Village, my lord,
No village.
Rangauti Part 3, my lord.
Huh?
Rangauti Part 3, my lord.
Rangauti Kurba. Rangauti, Rangauti, Part 1, comma, Moja. Where is your Moja?
Moja Rangauti Part 1. Can you see, my lord, Schedule 1, my lord? Schedule 1 and Schedule B details is there.
Moja cannot be Rangauti Part 1. Where is your notice?
26, my lord, please.
Okay, Moja Rangauti Part 1. Hailakandi Revenue Circle. District Hailakandi.
Hailakandi.
Okay, Roman 1. An area measuring 6 Chotok, 13 Gonda, comma covered by dag number 570 and patta number 243 and 2 an area of land measuring 1 katha, 3 Chotok, 7 Gonda, comma covered by dag number 571 and patta number 244 within bracket subject plot number 1 and subject plot number 2. Post para. The petitioner has claimed that the aforementioned 2 plots of land came under the purview of land acquisition under the Asamala project initiated for widening of Hailakandi - Silsor Medical Road, Medical College Road, right?
Yes, ma'am.
Post. Insofar as the plot, subject plot number 2 is concerned, there is a litigation presently pending before whom?
Before the minor,
Before the court of Learned Munsif, Hailakandi, in title suit number 17 of 2014 between the petitioner as one of the plaintiffs and these respondents, private respondents they are defendants.
Yes, my lord.
Where are their names?
Lordship,
Sarifuddin Chaudhuri.
Sharifuddin Chaudhary is
Where?
not the defendant, my lord.
Where? Number?
He is not the defendant in title suit, my lord. He is the opposite party in notice, my lord.
Okay, then this
26
Sabia and 5, 6, 7, 8, 9.
They are the plaintiff in my
Huh?
lord. They are the plaintiff in title TS number 17, my lord.
They are the plaintiffs.
Yes, sir. Plaintiff in TS number 17, my lord.
Hmm.
And TS number 24, my lord.
This Sabia. Where the respondent number 7, 8, are also the plaintiff number 3 and plaintiff number 4 respectively. Full stop. In matter of claim for subject plot number 2, comma, a dispute is also pending.
Annexure 8, page 44, madam. Annexure 8, page 44. TS number 87.
Abu Yusuf Sodri. Who is Abu Yusuf Sodri? Okay.
He is the petitioner in the
Poijur. Okay. Same subject plot.
yes, my lord.
Huh?
Same, my lord.
In respect of the subject plot number 2, another title suit, title suit number 87 of 2021.
It is a
Between
my lord.
Between the respondent number 7 as the plaintiff and the petitioner. Within bracket, defendant number 1 and the respondent number 2 within bracket, sorry, respondent number 6 within bracket, the defendant number 2 is also pending before the Court of Learned Murshid number 1, Hailakandi. Full stop. In respect, as regards the matter of compensation for matter of compensation and for determination of the person interested in respect of the subject plot number 2, a proceeding, miss case number 09, 2024 is also pending before the additional district commissioner within bracket LA stroke executive magistrate, Hailakandi. Full stop. Para, it is a case of the petitioner that insofar as the subject plot number 1 is concerned, there is no dispute on the point that the petitioner is the claimant. Petitioner is the person interested who is entitled to receive the compensation determined in the concerned land acquisition process. Full stop. Para, it is submitted by Mr. Loskol and counsel for the petitioner that claiming disbursement of the compensation determined in respect of the subject plot number 1, the petitioner has submitted a representation.
2 representation, my lord. 2
That
representation.
already has submitted representations, dated 11/2/2025 and
23/5.
where is that?
Annexure 1, my lord. 23
Annexure
1,
page
page 19, my lord.
representations, dated
23/5/2023.
where is the date? 23/5/2023 and dated 11/2/2025. Before the district commissioner chairman. What is that? District, what is DLLPC? District Level Land Purchase Committee, Hailakandi. As the said representations are not disposed of till date, the petitioner is before this court by the instant writ petition seeking inter alia direction to the respondent number 2 to take the said 2 representations of the petitioners on board and thereafter, to dispose of the same. Post of para. Ms. Borman, learned junior government advocate. representing the respondent number 2 and 3 has submitted that since the petitioner has claimed that claimed that there is no dispute as regards the ownership of the subject plot number 1, and the petitioners claiming disbursement of compensation determined in respect of the subject plot number 2 has already submitted 2 representations. Aforementioned 2 representations, this petition can be disposed of with a direction to the respondent number 2 to consider those representations in respect of consider those representations with regard to the matters of compensation and disbursement in respect of subject plot number 2. Post of para. Having heard the learned counsel for the parties and considering the claim made by the petitioner that there is no dispute, as on date, as regards the ownership of the subject plot number 2, and the petitioner has already submitted 2 representations before the respondent number 2 on so and so respectively, and those representations are not yet disposed of till date, this court is of the considered view that instead of keeping this writ petition pending, the same can be disposed of with a direction to the respondent number 2 to take the said 2 representations dated so and so, stated to have been already submitted before the respondent number 2 by the petitioner, on board, and thereafter, to consider the same and thereafter to consider and dispose of the same by passing a speaking order. Post stop. It is accordingly ordered. Full stop. It is further observed that the respondent number 2 shall consider the said 2 representations with regard to the claim of the petitioner. With regard to the petitioner's claim for entitlement to receive the compensation determined in respect of the subject plot number 2, and thereafter dispose of the same on its own merits. Post stop. It is further. The entire process, the entire exercise shall be within a period of 4 weeks from the date of submission of a certified copy of this order by the petitioner and the office of the respondent number 2. Full stop. It is further observed that this court has not observed anything as regards the claim of the petitioner regarding his entitlement to receive compensation in respect of the subject plot number 2, and the respondent number 2 shall consider and dispose of the representations on its own merits and in accordance with law. Post up with the above observation and direction, the petitions is disposed of. There shall be no order as to cost.
Worship, till disposal of the representation, my lord, the compensation amount should not be disbursed. Compensation amount in respect of plot number 2, my lord.
Is not since 2023 is not disbursed, and you are saying there is no claim. You are the only claimant.
Yes, ma'am. In respect of plot number 1, my lord, I am the.
There is so many litigation pending.
In respect of plot number 2, my lord, pending.
Yes, plot number 1 is concerned.
Yes, ma'am.
We are disposing of only plot number 1.
Yes,
That is your only prayer
Yes.
in the writ petition.
Yes, ma'am.
Why should we broaden the scope of the writ petition?
Most of them.
There are 2 title suits pending, 1 proceeding pending. So far, subject plot number 2 is concerned, your claim is limited to only subject plot number 1.
Yes, ma'am.
That's all.
Most of them.
Item number 20.
Please, your lordship. This time we come up with a schedule. I'm suffering from cold actually. So
Did you prefer an earlier application?
that has
Yes.
been withdrawn with legal.
Where is the mention?
Oh, that I have not.
Where is the mention?
This lordship's query was that we did not put any schedule, so we have come.
Right, that you had withdrawn
Yes.
the earlier petition, where it is mentioned,
Oh, that I have not mentioned, your lordship.
then
I will file an additional affidavit, lordship. Let me.
I remember you are the counsel.
Yes, your lordship. I may be allowed to file. I will file.
It is up to you on the prayer of Miss, as the executive learning counsel for the petitioner, the case is adjourned for a week,
For a week, your lordship.
for a week.
Item number 21.
Yeah, please.
Yes,
Here, what has happened is the.
brother joint Patadar situated Thakuri.
Using a Assamese phrase, my lord, দুই মোহর যুঁজত বিৰিণাৰ মৰণ. Someone filed a suit.
Let us see your synopsis, let
My
me
lord,
understand.
Yes,
The petitioner and his brothers joint Patadar of a plot of land.
measuring so.
Measuring so and so. Situated Bhagpuri Kural Bhanga under Mankasa Revenue Circle.
The
where
petitioner is the owner
petitioner is the owner of a plot of land. Measuring and covered by dog number so and so, situated adjacent to the soldier. The officers of the name in the executing a judgment order dated so and so in respect of another land. Another land. Periodical had wrongly demarcated the land of the petitioner and his brothers mentioned above, and erected pillar through the middle of the dwelling house of the petitioner, for which the petitioner and his brother are now on the verge of losing a plot of land measuring 1/5 from the aforesaid scheduling dark number 74. 73, dark number so with several applications due to various remarkable land and they have been handed over them their plot of land taken Mr. Mozumdar,
My lord.
by executing a decree, civil court erected pillars.
No, my lord.
No, that is what your synopsis is.
Yes, yes.
Let us see the second page of synopsis.
Yes, my lord. And
Third line,
ordinance of-
had
yes.
wrongly demarcated the land of the petitioner and
My
his
lord.
brothers
And brothers.
mentioned above and erected pillar through the middle of the dwelling house of the petitioner.
What has happened is this. my lord.
For which, 1 minute, that is your synopsis,
It is, it is.
for which the petitioner and his brothers are now on the verge of losing a plot of land measuring so and so and so and so. So, execution of a civil court's decree,
Yes, ma'am.
erected pillars
Yes, ma'am.
and dwelling house,
My lord.
that part is gone.
Now, lordship,
Now,
can-
demarcation cannot be ordered to that part. That part is gone. You have to,
What I
or
was-
because
what I was
demarcation,
trying to dis-
no, well, just a minute.
Yes.
Then you explain. Demarcation can be made only in respect of the area of land where you claim ownership and where you have the possession. By execution of the decree of the civil court, by erecting pillars, one part is gone. The remaining part I can examine, but civil court's decree, I am not entertaining
I am-
at all.
I-
You have to prefer application
I am
for
not-
that.
I am not aggrieved
Yes.
by the orders of the civil court.
Hmm,
I am not aggrieved at all.
hmm.
What has happened is this, my lord.
Hmm.
One person, lordship will find it page 44. A little, my lord, indulgence. Page 44. One Akkas Ali
Hmm.
files a suit against 4 persons.
Hmm.
I am not there. My piece of land is not there. Nothing happens. They get an ex parte decree. They try to get it executed. Now, lordship should kindly have page 68 for a minute. This was my application when they
demarcated the land per the, according to them, as per the decree. Lordships will kindly have page 69 for a moment. Page 69, the second paragraph from the top. What they've done is, since it is on the Meghalaya boundary area, they did not measure it from the pillar on the boundary or wherever near it was. They took the most convenient place, started measuring for the demarcation, which led up to my residence. If the demarcation per the suit, per the decree is done appropriately on the markings given for such demarcation, my house does not, my land does not come anywhere within this.
Right, but the Deputy Commissioner or Circle Officer is executing a decree of the Civil Code.
Yes.
They are not acting on their own.
No, they had to demarcate it from the appointed pillar. There are pillars which are given for demarcation. It is not done on the air. Because it is on the border, they take it 70 feet inside the border. They do not do it from the pillar. They encroach upon my land while demarcating it. I want the decree to be executed. I have nothing to say against the decree.
Right. Now, which is a proper forum? Because I'm trying to understand. Because Deputy Commissioner is acting or whatever.
We are not.
All this, they are acting under authority of the Civil Code, executing code. And whether this kind of petition is maintainable before the executing code, that is what I'm not very conversant with CPC.
Well, what I would
and so you must have read the CPC.
What I'm trying to
if somebody's right is affected while execution of a decree.
My right is not being affected by the decree at all.
No, Mr. Muslim,
the decree doesn't touch my piece of land.
Mr. District Commissioner is not acting on his own authority. Here, the role of
what I was praying is that the district commissioner acts on it. Let him act on it. Let him act on it from the designated post where he should act from it, act from.
So
it
that
cannot be a case.
Where there is two different. One is that the Deputy Commissioner or District Commissioner acting on his own authority. That is one part.
That is one part.
And the other part is the Deputy Commissioner or Circle Officer, wherever, they are acting under the order of an executing court.
True.
Right. And this act appears to be under the authority of the executing court.
True.
Right. And so whether the civil court, they are acting under the umbrella of the civil court. I am just trying to understand the issue. Right. Had it been a simple demarcation application before the district commissioner or circle officer, he would go and do it. Right. But here, all this Nazir and all of whatever, going to the plots of land. Right. This Nazir and all has put their stamp of approval on the pillars which had gone through your house. That is what you said.
They installed those pillars to demarcate it. These are not the pillars which initiate the demarcation.
Now, what do you want at this stage?
There are two representations that I have filed. One which I have just shown to Lordships at page 68, 4th of March, saying that kindly do it in the corrected manner from the place where you should actually demarcate it. And my second representation lies, my lord, at page.
What is this page 73?
Page 73 is when they called me and the other party for the demarcation. I approached, I appeared. They did not come. Nothing happened on that day.
This application is for what?
My lord, for the demarcation. After
your application?
Yes, they came. Because the other party did not come, nothing proceeded.
Mr. Sharma.
Nothing proceeded. That is the whole issue.
Yes.
It is only a correct demarcation I pray for.
Try to get instructions and.
I should place it before Lordship or not. Incomplete copies upon me.
Oh.
Pages not now your Lordship is.
Okay.
I have not found. 70 people have.
I apologize, my lordship will have it. Lordship is tomorrow or day after.
Get the full copy, then come up with the instruction.
I apologize.
Because one decree has been executed.
Lordship, that
And
is
as
why
per
I
the
asked that
synopsis, I have not gone through
question. That
anything.
is what has happened.
And you said that these pillars have been erected through the middle of the dwelling house.
Now,
So if the civil code decree, civil
Being
code has already said that decree has been executed
it can be done.
and this has
Yes.
gone through the dwelling house of the
My
petitioners,
lord.
then issue is completely different.
Thing is, had
So
they
what
measured
cannot
it
be
from-
done directly cannot be
what-
done indirectly.
Had they measured it from a
So
particular.
I can only say that if his civil code is already decree has been executed,
Yes.
only whatever is under possession of the petitioner, that can only be demarcated because that is civil code decree. Have you understood?
I have totally understood. My case was that execution had to be done from a particular designated point. That is what not done.
That in a
was not
read
done.
code, when a civil code decree has been executed, whether this read code can.
Whether it has been.
Yes,
whether
that
it
is what
has
I am
actually-
saying.
Whether it was
You
actually
claimed,
properly
say,
executed is.
2 bighas and 1 bigha is gone by the execution of civil decree.
Now that part I'm getting.
I cannot direct
Cannot.
that you decide demarcation of entire 2 bighas. 1 bigha, if 1 bigha is gone already. Have you?
I get your point.
So
But
decree-
my line of thinking was a little different where a proper.
From the pillar,
demarcation-
beyond the pillar, I can say, yes, consider.
Whether the pillar was actually properly
That
established or not was my case.
because that part, whoever is there, they have done as per the decree of the civil code. Deputy commissioner has no independent role there, circle officer. It is Nazir, whoever goes there, he puts the approval, then he'll place that we have done and place it before the civil code. And he puts the stamp of approval.
There it was.
Then that pillar, that part is executed.
As per the
is different.
decree, was it as per the decree or not? Is
Mr. R. Mujumdar and Council petitioner shall supply a complete copy of the petition along with annexer to Mr. Sharma, H. Sharma, and additional senior government advocate. By tomorrow, let the case be listed on Friday again.
Bless me.
Number 22.
Yes.
My lord, I am aggrieved by my lord, the notice page 47 and page 48.
Page 48. Udalguri.
My
Udalguri. Reference to so and so regarding position received from the Khantari Pukri Committee. Borigaon Jankor Khantari illegal road. From page 48, it looks like there is a previous proceeding. Previous proceeding.
Yes, that is my lord, page
What is?
47.
Huh?
That is page 47.
37.
47 is the first notice.
47.
Yes.
Yes.
But my submission is this, my lord. That first of all, my
Hearing
lord,
held on 16 December. The road.
first of all, my lord, this petitioner has been my lord from a long position, that is government land. And my lord, land is not for my lord roadside or PGR or VGR or reserved for any my lord purpose. It appears from the page 47 itself. And my lord, the particular of the land is also not given in the side notice, page 47.
Yes, madam.
Lordship, the instruction lordship of how much land he has proposed.
Okay. We'll issue notice at this stage. Status quo. Heard. Mr. S. Rohan. Learned counsel for the petitioner. P.R. Mohanto. Learned standing counsel, Revenue and Disaster Management Department for respondent number 1. R.B. Bora. Learned standing counsel. BTC. Respondent number
5.
2, 3, and 5. M.S.M. Bormon. Learned Junior Government Assam for the respondent number 4. Full stop. The petitioner has claimed that the petitioner and her family having in possession of a plot of government land measuring 5 bighas
My lord.
under Dagnaba 99, located in village number 2, Uhurabari, Moja, Udalguri, Udalguri Revenue Circle, since about last 5 decades. Post up by a notice issued on 13/12/2024, the respondent of 5 had asked the petitioner to appear for a hearing on 16/12/2024 on the ground that he had received a complaint from the respondent number 6 and 7
Fine.
regarding allegation of illegal encroachment. Thereafter, by the impugn notice dated 13/2025, Annexure 23. The respondent number 3 has observed that in the impugn notice, it is issued to the petitioner, the respondent of 5 has observed that the petitioner has illegally encroached on the road from number to Uhurabari to Borigaon Jungle, and therefore, the petitioner should remove the obstruction stroke encroachment Mr. Sohan,
My lord.
did you submit anything?
Yes, my lord, I accordingly appear and submitted whatever document with me.
No,
my
no,
lord.
after
Yes.
13/12/2025. Because you were asked to explain.
My lord, yes, I appear.
Huh?
I appear.
And did you submit anything?
Yes, my lord. Document submitted, my lord.
Hmm?
My document only submitted. I submitted my documents. And my lord, in first notice, encroachment of road is not there. In the second.
Second notice, then
Yes.
you have been asked to explain.
Yes, I appear, my lord.
Then
And
let him
and verbally I submitted, my lord.
verbally submitted. Then what is your bona fide claim then?
My lord, verbally, my lord, I am not, my lord, asked to submit anything more. Because
If you have a right, bona fide right, with respect to all these plots of land, then only verbal submission will not do all this khazna, land, everything you should submit to him. That I have a bona fide right and I am not encroaching anything. That is the law now.
That's right, my lord. But I appear, my lord. I have stated I appear, and I.
Your
submitted
mere appearance will not do.
Before the
It will be
circle
construed
officer-
then.
Before the circle officer.
Then you submit all the documents in support of your claim, bona fide claim for possession of the land in question, then he will pass an speaking order. Now there is a law. And if it is road land you are encroaching,
Well,
then in spirit it is 18(2).
my lord, I have stated in my petition that I submitted the documents, my lord, in paragraph 16.
Okay. Then let him pass a speaking order. Till then,
But my lord.
there shall not be any coercive action.
Yes.
কি করলো লাস্ট হ্যাঁ the petitioner কি করলো encroach করলো না encroach করলো হ্যাঁ and petitioner has been asked to appear before the respondent of 5 on 17/2/2025 to explain her case, or else necessary action would be taken as per the relevant laws. Post of para, Mr. Chauhan, the counsel for the petitioner submitted that on receipt of the notice dated 13/2/2025, the petitioner has already appeared before the respondent of 5 and submitted all the documents with regard to the petitioner's claim, bona fide claim for possession and occupation of the land measuring 5 acres, covered by the Act number 99, located at village number 2, Puhrabari. So Mr. Chauhan has further submitted that the petitioner is not in possession, not in occupation of any land
Roadside.
with respect to the number 2 Puhrabari to Borigaon Jungle Road. Full stop. Where Ms. Bora, Land Standing Council PTC, has submitted that since the petitioner has already responded to the notice dated 13/2/2025, and if no speaking order has been passed thereafter by the respondent number 5, this petition can be disposed of with a direction to the respondent number 5 to consider the explanation given by the petitioner in the hearing before the respondent number 5 on 7/2/2025, and all other supporting documents submitted by the petitioner with respect to the petitioner's claim regarding possession and occupation of the land in question. Also, having on perusal of the notice dated 13/2/2025 issued to the petitioner by the respondent of 5, it is noticed that the petitioner has been summoned to appear before the respondent number 5 on 17/2/2025 to explain her case with regard to the allegation that the petitioner has illegally encroached lands falling within lands on the road on number 2 Puhrabari to Borigaon Jungle Road. Full stop. Since the petitioner has already appeared before the respondent number 5 in response to the notice dated 13/2/2025 and has submitted all the supporting documents in respect of her claim for possession of the parcel of land falling within Government Act number 99 at village number 2, Pohorabari, and in rebuttal of the claim regarding illegal encroachment on number 2, Pohorabari, Borigaon Jungle, the respondent number 5 shall proceed to dispose of the representation, dispose of, shall bring the proceeding initiated by the notice dated 13/2/2025 to its logical conclusion by passing a regent order. Full stop. Within a period of 1 month from the date of receipt of a copy of this order or date of submission of a copy of this order by the petitioner at his office within a period of months. So it is further observed that if the respondent number 5 reaches a conclusion that the petitioner is in alleged or petitioner is in encroachment of any area of land reserved for number 2, Pohorabari to Borigaon Jungle Road in the speaking order, then the respondent number 5 shall give an opportunity, shall not take further coercive action for a period of 1 month thereafter in order to facilitate the petitioner to avail appropriate remedy available under the law. So with the above observation and direction, the petition is disposed. So pass a speaking order,
My lord,
no
one-
coercive action.
One small prayer, my lord.
Ah.
Along this order, my lord, I may be allowed to submit my written reply again.
Okay. The petitioner is also granted liberty to file to submit further additional supporting documents along with a representation to supplement her claim her bona fide claim with regard to so and so and rebuttal of the claim of encroachment on so and so within a period of 7 days from today.
12%. Mail.
12%.
হার করে দিব,
Mail,
যত
mail.
আছে হার করে দিব।
He.
Instead of he, see,
Instead of C, he.
he is male person.
My lord, mail.
Huh?
Mail, mail.
Okay, he.
Much.
Different.
Item number 23.
May I please, Your Lordship? Lordship, my written representations and complaints referred from time to time were not taken care of. And
What? Unauthorized construction?
yes, my lord.
Any finality? No finality?
No.
Yes.
Notice also under section 337(3) is served,
Served.
but on field nothing has been done.
Yes, Mr. Nayak.
Lordship, page 168.
Notice.
Yes, 337(3), order, Lordship, in fact.
Is order to demolish. Then,
But not.
Lordship, may kindly see the deviation portion in the table below.
Huh.
One deviation is there, 0.185 meter. So subsequent thereafter, Lordship, I have to obtain instruction, what happened thereafter.
you are still aggrieved by this order or
Yes,
what?
Yes, my lord.
Non-compliance or the nature of the order?
So the nature of the order, further, my lord, kindly the next page may be seen, 169. My friend has referred to 168, I am referring to 169. This is an FIR, my lord, lodged by the respondent number 6. He is saying that the concerned file is missing from the office.
Hmm.
And after missing of this file, an inspection report was prepared by the then three zonal engineers of the corporation.
So, this proceeding, this page 168, was initiated at your instance.
Yes, I filed complaint
Yes.
and representations. Thereafter, initially under subsection 1 and 2.
No, I'm now I am asking whether you are aggrieved by non-compliance of this order or the nature of the order.
My lord, non-compliance also. And
Because
about
this is an appellate order, Mr. Nayak, whether an appeal lies at his instance.
And furthermore, my lord, the NOC that was issued to these private respondents, that is also put under silence. In
No,
the present writ process.
I have been saying, ordering, disposing writ petition because there is an appellate remedy before the district judge. That is why I am asking that whether you are aggrieved by non-compliance or the nature of the order, that instead of cantilever finding 0.60 meter, it should have been 2 meters like that.
That is not the violation. Only one violation.
No, I am just giving an example.
Yes.
Giving an example that you want this order to be carried out or you find that this order is not correct.
No, I am not saying that. My lord, the point is, when the concerned file is missing, there is an inspection report. After missing of the file since, as per this FIR 8/3/2022, the file is missing. Concerned file is missing. And these private respondents are asked to also submit the approved plan, which they have not submitted before the respondent number 4. That's why this order was passed. But there are some other issues also, my lord, such as about the quantum of the land. So initially, the application for NOC, it was preferred in the year 2014. And this NOC was granted in the year 2022. And in between, there is a title suit.
Right.
And in
That
the
is
title
why
suit-
that is why I am asking you
Yes, my lord.
2 questions specifically. One, that you need compliance of this order, or all those that the manner in which this order has been passed is not proper. Have you understood?
Prayer for cancellation of the NOC,
NOC.
as well as inaction of the authority in implementing this order. So I am accepting this as an coming down from cancellation of NOC to implementation of this order of 2022.
Because
Yes.
if only non-compliance, we can keep it. But if he says that planning permit was not there, then so many bigha permission was taken on 1 bigha, 1 kotha sam lesa, but later on title suit 1 kotha 2 lesa, all these are not to be gone into by this court. It is to be gone into by the appellate court, who is the district judge designated. Right?
One demolition order.
He can lead evidence on that and order demolition of all this. That
I'm
can
not
be
disputing that. Undisputed.
right.
One demolition order is there. Although he is praying for cancellation of the NOC, in this case, he is saying that if authority is doing nothing in implementing this order.
If that is only limited to that authority is not doing anything, we can keep the issue pending.
Yeah.
But in the meantime, your period of limitation for filing appeal will go.
Yeah.
This court will not be responsible for that.
Let notice-
So I am asking him
let
to
notice-
make the point clear.
Yes.
Because if you are not harping on those 1 kotha 2 lesa or 1 kotha 7 lesa, we are not examining that.
Yes.
Right?
Yes.
We will be only examining whether this order has been implemented or
Or
not.
not.
But in the meantime, they may file appeal.
That is for instruction for that purpose.
Ah.
Probably they have approached the.
Maybe district judge. In that case, he may participate.
Probably the authority is doing nothing. That is also.
Ah.
Let me have the instruction.
You get the instruction. 2 instruction. What action has been taken pursuant to this order, this 168 order, page 168, and whether any appeal has been preferred by the,
For that, lordship, notice to private respondents are necessary. First one.
no, you will be a party, otherwise not.
The appeal, lordship, I will be part.
That is why, if any appeal is filed, then we'll go to the private respondent. Heard Ms. B. Bora, learned counsel for the petitioner, petitioners, and Mr. P. Nayak,
4, 5, 6, 7.
Mr. Sharma, you for
3 and 8.
1, Chief Secretary,
Lordship, Chief Secretary.
learned
Two
Mr.
also I am.
Okay, Mr. H. Sharma, learned additional senior government advocate, Assam, for the respondent number 1, 3,
And 8.
8. Mr. P. Nayak, learned standing counsel, urban affairs also.
When
How-
GMC is there, I am. Okay.
Housing and Urban Affairs stroke GMC.
2, 4, 5.
Oh, it is only GMC, then no appeal. That appeal provision is under GMD Act. Only GMC, no GMDA.
Because
Then-
here, my lord, it is bypassed.
Case of GMC,
JMD.
Lordship, 337(3), that is the final notice, Lordship,
Yes.
demolition.
No.
But nothing has been.
In case of any order under the GMD Act for demolition, that is 88 or 87, there lies an appeal before the district judge. That is what. But here is not a case. GMD is not involved. Okay, then we'll issue notice. We'll issue notice that. I thought it is GMD.
No.
One appeal provision is here also, lordship, before the, I mean, mayor in council or something like that. Before the mayor. I think.
Okay.
Okay, they are the group.
But he is not a judicial authority. The petitioner is aggrieved. Petitioners are aggrieved by non-implementation of an order dated 27/5/2022 passed by the respondent number 3, whereby the respondent number 3 has ordered for demolition.
No, my lord, 5. Respondent number 5.
Respondent 5 has ordered for demolition of a building constructed by the respondent number
9 to 12.
9 to 12. Post of issue notice returnable on so-and-so date as so-and-so has appeared, accepted notice on behalf of the so-and-so, issuance of formal notice to the said respondents and dispense with the petitioners shall take steps for service of notice upon the respondent number 9 to 12 by registered post AD within 2 working days from today. Now, Mr. Nayak, learned staying counsel GMC shall obtain instruction as regards the action taken by the respondent GMC authorities pursuant to the order dated 27/5/2022.
Sorry, your lordship, I am making the mention because of one unfortunate scene, your lordship. Tomorrow morning in court number 2, one matter was mentioned relating to my lord eviction from my quarter, your lordship. Mention was allowed by this honorable court, my lord. My lord, it may be that nowadays there are different sets of that is this will go in this bench or that bench. Everything is ready. Now registry is saying that bench is not allocated for this matter. So this matter will not be listed. You have to mention before this honorable court.
Yes.
So my lord, I am mentioning because of that. Otherwise also, my lord, when the honorable senior judge has allowed mentioning, in my humble submission, your lordship, it has to be listed, my lord,
When?
in the appropriate today, my lord, because commissioner is sitting to evict me. Everything is ready in the bench, your lordship. If the learned,
You don't read the roster.
so many different type of matters are there. So far as this earlier it falls under my lord residuary writ petition, my lord. A number of matters were done before bench 4, your lordship. Even if my lord, it falls under 5, when the honorable senior judge has allowed mentioning, it has to be listed, my lord.
Okay, listed.
My lord, deeply your lord.
Supplementary list, item number 55.
May it please, your lordship. Lordship, here these petitioners are the villagers of one Narayanpur Part 2, which ought to have come within ward number 6 of Narayanpur GP in Hailandi district. But when the final list was asked to your Lordship, it is found that they have been some of the petitioners from village Narayanpur Part 2, some of the voters, household number 31 to 69. They have been shifted to ward number 7 instead of ward number 6. And this ward number 7 is at a different place. Ward number 5 is in between ward 6, ward 5, and then ward 7. Even there is no geographical continuity with this new ward to which they have been given your Lordship. So being aggrieved, they have also filed a representation, but they are not also acting on it, your Lordship.
Okay. Get your instruction relation notice at this stage.
Presentation is dated 15/3.
15/3.
The same has been given to election officer at page 54 also.
Page
Page 52.
52.
This is before the district commission. And 54 is the before the election.
It's 12/3. 12/3.
Yes, what is your submission? Okay. Okay. You want instruction? So after what?
3/4 days, your Lordship.
Okay. Heard Mr. M.H. Loskor, learned counsel for the petitioners. K core.
For 1, 2, 3, and 4.
Senior Additional Advocate General and Senior Standing Counsel Panchayat and Rural Development Department for as per number 1,
1, 3, and 4.
3, 4, and Mr. R. Dubey, learned Standing Counsel, Assam State Election Commission for as per number 2 and 5. Full stop. Have been regard to the nature of grievance raised by the petitioners in their representations as well as in the present petition, Mr. Kaur and Mr. Dubey have submitted that they would make endeavor to obtain the necessary instructions in the case. Full stop. As sought for by so and so and so and so, place the case on so and so
Friday.
to enable them to obtain the necessary instructions. Monday?
Monday is a holiday.
Monday holiday?
Friday will be better, Lordship. The delimitation matter election will be notified anything.
Okay.
Oblige.
Oblige.
Item 56.
Yes. Time being.
Pending letter, I don't know one.
Lordship, in this case, the construction of drainage has been challenged by the petitioners over their Patra land. Now, my lord, the joint inspection was done, wherein my lord, an affidavit, based on which my lord, an affidavit has been filed. An affidavit has been filed, my lord, by respondent number 3.
That was as far back as in 17 February 2022.
22, my lord.
3 years.
3 years, my lord. But in this way,
And report is also there.
report is also there, my lord. So, my lord, if they construction on my lord, drain over the government land without touching the Patra land of the petitioner, I don't have any grievances, my lord.
So according to their report, there is no encroachment.
They say no, but why, my lord?
If you have still grievance, then writ petition is not, because again, if your claim will be then disputed question of fact.
No, my lord, they have, yeah.
That is in your presence. The joint verification report, that
In
is the
terms-
order.
In terms of order of this report, my lord.
Yes, you agree to that order that on this particular date,
30/11/21, my lord. 30/11.
authorized person, the petitioners and their authorized person.
Yes, my lord.
It was carried out. And I think that the report is there
At the time, my lord, at the time of inspection, my lord,
that পট্টাদাৰ মাটিত কোনো নিৰ্মাণ কাৰ্য কৰা নাই, পট্টাদাৰসকলৰ অভিযোগ সম্পূৰ্ণ ভিত্তিহীন।
at the time of my lord inspection, they found that the earmark, the area of land to be over which my lord construction is to be done, has been excluded, my lord. Earlier, Patra land was encroached, my lord. That's why petitioners have approached this honorable court, my lord.
So, what to do?
Your lordship, I can dispose of the same.
Because as per report, then you want to change.
If they are not,
change.
not going to encroach paternal land, petitioners are not having grievances anymore, my lord.
So we are closing this. If you have any grievance, further grievance, you
My lord,
seek appropriate remedy.
my lord. But my lord,
If you dispute it, then
well, in terms of this affidavit, my lord, they may be allowed to raise construction over normal land without touching paternal land.
yes. Yes, Mr. Kumar. Heard. Mr. N. Alam. Learned. Counsel for the petitions. PWD. Call PWD. Ms. P.R. Mohanto. Learned Junior, Learned Standing Counsel, Revenue and Disaster Management Department for the response number 1. Mr. Sorenso, Learned Standing Counsel, Public Works Department for the response number 2, 5, and 6. And Ms. S. Kaur, Learned Junior Government Advocate, Assam for the response number 3 and 4. Full stop. Para. The petitioners, comma, 5 in number, comma, have approached this court. Stating internally that there are owners and partners in of different parcels of land situated at a village, Hakusi town, comma, Moja Kilajari, Borpeta Revenue Circle.
May I please, lordship, Sonkusi, my lord. Sonkusi.
Huh?
Village is Sonkusi.
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 You said Hakusi.
Like Sonkusi.
Okay. S-O-N.
S-O-N, my lord.
Abutting. The eastern side of the Borpeta town, there's Howley Road. Post. The petitioner once stated that he is the owner of so-and-so on behalf of so-and-so land covered by so-and-so, paragraph 4. Petitioner 2, 3, and 4, paragraph 5 what I said. Petition number 5, paragraph 6 what I said. The petitioners have contended that our ward number 14 and 15. The respondent authorities in the Public Works Department, Government of Assam, had started construction of a wide drain by the side of the Borpeta town, Howley Borpeta town state highway. And in front of the parcels of land belonging to the petitioner. Post up. The petitioners have further contended that without taking over their any parts of the parcels of land, belonging to the petitioners, as per the provisions of law, the respondent PWD, the respondent authority in the PWD have been constructing the drain over their patta lands, demolishing the structures standing over the petitioners' parcels of land, including houses and others. The petitioners have further projected that the petitioners submitted representations before the respondent authorities in the Public Works Department with a prayer to construct such the drainage system on by the side of the Howli, das Borpeta town PWD road, leaving their patterlands. Post of Para. By an order dated 22/11/2021, this court, after hearing the learned counsel for the parties and considering the facts projected by the petitioners, had directed the Deputy Commissioner, Borpeta, or any authorized person on his behalf, Colon, in the personnel of the land acquisition branch of the office of the Deputy Commissioner, Borpeta, semicolon, the circle officer, Borpeta Revenue Circle, Borpeta, and the executive engineer, PWD, Rongia National Highway Division, Rongia, or his authorized person, with their man and material to measure the relevant road and the drain then being constructed by the side of the Howli, that's Borpeta State Highway, in which has gone by the front of the parcels of land, belonging to the petitioner on 30/11/2021, in presence of the petitioners or their authorized persons. First up, the petitioners were directed to produce the relevant records in original regarding their parcels of land covered by tag number so and so, and pattern number so and so at village Sonkusi town, Moja Gilabari, Borpeta Revenue Circle, district Borpeta, including their respective parcels of land and its schedule as settled with them by the settlement authority for necessary examination. Post of para by the order dated 22/11/2021, further observed that after such joint survey joint verification of the land as directed above, the Deputy Commissioner Borpeta as well as the Executive Engineer PWD Rongia National Highway Division Rongia shall submit their respective reports before this court. Post of para. After the order dated 22/11/2021, an affidavit in opposition has been submitted by the respondent number 3, that is the District Commissioner Borpeta, on 17/11/2022, enclosing therewith the report of the joint survey verification carried out on 30/11/2021 as per the direction of this court. Full stop. As per the affidavit in opposition filed by the respondent number 3, after making measurements of the parcels of land as well as belonging to the petitioners and the parcel of land where the drain has been constructed during the joint survey stroke verification. It is found that there is no construction in the periodic pata lands belonging to the petitioner. And it is ever that the claim made by the petitioner is found to be baseless. First of it is further ever that there is no encroachment over any periodic pata land while constructing the drain, and the drain has been constructed only over government land. First of the mentioned facts are also recorded in the joint survey stroke verification report submitted annexed to the said affidavit in opposition. First of on perusal of the report, it is found that it is noticed that the report has been submitted. After carrying out the joint survey stroke verification of the parcels of land belonging to all the 5 petitioners and government land over which the drain has been constructed. Full stop. It is recorded in a report that the Public Works Department has constructed the drain over the government land measuring 30 meter within bracket 100 feet on the Borpeta Howley Road, and the PWD Public Works Department has not made any construction of drain over the land of the petitioners. Full stop. Para.
Yeah, please, Lordship. Lordship, inspection was done on 30/11/2021, my lord. In terms of order of this on court, my lord. This report is of 17/11 prior to inspection, my lord.
9/12/2021.
Well, Annexure 2 is of my lord.
Annexure 1.
But Annexure 2 is Annexure 1 has been.
Okay, I'll record more.
My lord.
As per the report dated 9/12/2021, annexed as Annexure 1 to the affidavit in opposition, the joint survey stroke verification was carried out on 30/11/2021 in presence of all the petitioners, and during the joint survey stroke verification, the boundary is of the petitioners and the adjacent land, government land, where the construction of the drain has been carried out, where the construction of the drain have been duly identified. Post of. But in such view of the matter, in view of the above fact situation obtaining in the case, it primarily emerges that during the joint verification stroke survey stroke verification carried out on 30/11/2021, the boundaries of the petitioner's parcels of land and the government lands where the construction of the drain has been carried out, where the drain has been carried out, have been duly identified. Recording a finding that the drain has not been constructed, has only been constructed on government land and not on any land belonging to the periodic patha land belonging to petitions. Post of para, if such in such view of the matter, commander writ petition. This court is to consider from our view that the writ petition, there is no serving cause for this writ petition. Because there is a cause, like if the petitioners want to seal the findings recorded in the joint survey stroke verification report, carried out in terms of the direction of this court, in terms of the order dated so and so of this court. The petitions are at liberty to avail any other appropriate remedy as in the event of such any such challenge, disputed questions of fact would fall for consideration. First up, the writ petition is closed with the opposite observation. First of the interim order passed earlier stands recalled. আৰু কিবা আছে? কি আছে? দুই নম্বৰ কেইটামান আছে? Okay, মাটি 56.
Number 56. May it please your lordship. My lord, these petitioners, they are basically a lessee of the Panchayat department, my lord. Now this impute notice has been issued at page 31, my lord. It is hereby informed that persons encroaching possessing land covered by so and so of vizier land of Silpukuri Kisamot Dag number so and vizier land of so so under Silpukuri Moja Mikirveta Revenue are ordered to vacate the land for passing water from Pujibi. The notice is issued under Rule 18.2. I don't think, my lord, the Rule 18.2 can be invoked in such a situation because if your lordship would kindly come to page number 21, my lord. This is Botodroba Ancholik Panchayat Patta issued to shopkeeper for Veti. Veti is that Assamese expression.
Do you have the copy of the Sita of Vizier? This 605 and 286.
No, Miller. It's not a vizier, Miller.
Because it's clearly
they
says
claim-
vizier.
They claim.
Yes.
In any case, my lord, prima facie, the Panchayat has permitted us.
That is for Veti, to set up Veti.
Yes, Veti.
Veti.
Ah.
But is there any Dag number?
Yes, my lord.
Where?
It is notified that Patta in respect of Veti under so and so.
They cannot give patta. That is for to occupy the vita, Veti or vita.
Yes, basically, my lord. So therefore, we are not unauthorized occupant or trespassers or something. At least we have some right to litigate, my lord.
Yes. But do you have any copy of the Sita?
No, we don't have. But, my lord, to our understanding, this is a land which belongs to Ancholik Panchayat, my lord. And it's a Panchayat land. And Panchayat has permitted us to occupy. Well, the question is in such a scenario whether the circle officer has the power. Well, more or less in a similar situation, there is a judgment of our High Court, my lord.
I think instead of president, you should have made chief executive officer Botodroba Ancholik Panchayat as a party. Otherwise, it will take long time to decide.
No, we'll make them, my lord. If necessary, we'll.
Because then
permit us.
Panchayat standing council can come in.
Yes. No, we'll do that, my lord. Lordship will kindly permit us. We'll file the revised memo of appeal shortly.
Because if 18.2 is there,
yes,
and it is vizier, then 82 will come in.
No, if it is vizier, 18.2 will come in.
Yes, that is
But-
why
but
he
the-
said,
Ah.
Jodi kunubai bedokhol kori ase.
No, my lord will kindly.
Why don't
come-
you respond it to it?
No, my lord, kindly come to this, this is a judgment which I placed just now, my lord.
Sahidul Islam.
Milord Sahidul Islam, yes. Now please come to para 8, Milord. After referring to that decision in Salakuddin's case, para 8, in the aforesaid settled proposition of law, let this court consider the factum of the present case. In the case in hand, petitioners have claimed a bona fide right to continue over the shops for the reason that shops are being run under Anchalik Panchayat. At the same time, the notice is silent as regards the nature of the land, which is also not permissible under Rule 18.2 of the settlement rule, inasmuch as an assertion is required to be made whether the land is a khas land, government khas land, or reserved for any grazing ground, or for reserved for India, etc. That being the position in the considered opinion of the court, the impute notices issued to the petitioners are not even sustainable under scheme of Rule 18.2 of the settlement rules. Accordingly, same are set aside. Exactly similar situation, Mila.
Okay, Mr. Gautam, you implement
Yes,
this
we do that.
chief executive officer, then
Yes.
we'll expedite the issue.
Yes, yes.
By tomorrow, you file the amended, we'll keep status quo.
Yes, please.
Till
Status quo
Friday.
Regarding Lordship, as because apparently Lordship is a vigilant and the judgment which my learned senior friend is relying upon, there the nature of the land was silent in the notice. Here in the notice, Lordship, it is apparent that it's a vigilant land. Vigilant land, Jagpal Singh's case is applicable, Lordship.
Why don't you get the record revenue?
Yes.
Chita,
Lordship. But,
also in the meantime.
But this status quo, Lordship, I am objecting, Lordship. This status quo, as because 18.2, Lordship, 4.2, it can be done.
Otherwise, it
No
will-
notice is required.
It otherwise be too late. Means no, there is a notice is required.
No, in 18.2, no notice
No,
is
no,
required.
no, it
That's
is
because the
required.
eviction can be made
Full
forthwith.
bench has said, division bench has said it is required. The Salakuddin's case, our High Court has said it is
But I
required.
have objection regarding that interim prayer.
Let the standing council, Panchayat and Rural Development Department come in.
Yes,
Then he can make the picture clear
yes.
whether it is a PGI land or Anchalik Panchayat.
Then your Lordship may kindly make it within a time frame, Lordship.
Yes,
Within
yes.
1 day, 2 days.
I am
Lordship.
permitting,
Otherwise,
no, I am permitting
after
Mr.
getting
Gautam,
interim, Lordship.
I am permitting Mr. Gautam to file the amended cost title. By tomorrow, we'll keep it on Friday. Then standing council will come in.
Okay.
Till then, it will stay. So thereafter, we'll proceed.
But my that objection, Lordship, because apparently it's a visual land. Lordship. Had there been, had it not been a visual land, Lordship, I would not utter a single word. Lordship.
I don't know for what reason.
But
he is,
in the same fact situation, this was the order. And the
There is-
petition was allowed.
Nature
Not
of
even
the
a
land
stay
was
order.
not mentioned in the notice in that judgment which my learned senior is relying upon.
Heard.
There, it is not mentioned.
I heard Mr. K. Chaudhary, Learned Senior Counsel, established by Mr. N. Gautam, Learned Counsel for the petitioners. And Mr. Pierre Mohanto, Revenue 1, Mr. A. Sharma, Learned Additional Senior Government Advocate for the response number 2 and 3. The petitioners have claimed that they are in occupation of petitions.
I am 2 and 3. Sir.
Since, yes, 2 and 3. Since about 2016 onwards, after pattas were granted to them by the Chief Executive Officer, Botodrova Anchalik Panchayat, Nagaon. And the petitioners are running their businesses from the shop houses on the basis of the pattas granted by the state authority. The petitioners have approached this court after issuance of a notice by the respondent number 3, asking the persons to vacate areas covered by DAG number 605-526 within bracket VGR of Silpukuri Kesamot. Dark number 286 within bracket VGR, Kujiyotra Kisamot, and dark number 1 VGR, Kohua Ati Kisamot within Mikir Bheta Revenue Circle. Full stop. It is a case of the petitioner that the vetis in respect of which they have been granted pattas fall within
Bhatadroba Anshalik Panchayat.
Anshalik Panchayat, Bhatadroba lands belonging to the Bhatadroba Anshalik Panchayat. Full stop. Para, as the pattas to the petitioner have been granted.
Lordship, one thing I want to point out, Lordship, the annexures, Lordship, which they have annexed, it is regarding only 3-4 petitioners, but it is seen that about 42 petitioners are here, Lordship.
Okay, let us have the
No,
check
we
here.
have, my lord, we have. We have.
As the petitioners have been permitted to run their businesses on the basis of the pattas given by the Chief Executive Officer, Bhatadroba Anshalik Panchayat. This court is of the considered view that Chief Executive Officer Bhatadroba Anshalik Panchayat is a necessary party in this writ petition. First, Mr. N. Gautam, Learned Counsel appearing for the petitioner, has submitted that he will file an amended cause title in terms of the notification dated so and so by tomorrow to implead the Chief Executive Officer Bhatadroba Anshalik Panchayat, Nagaon, as a party respondent. Full stop. Let the case be listed on Friday. Full stop. Having regard to the projections made in this writ petition. Mr. Sharma, an additional senior government advocate, has submitted that since the lands the petitioners are occupying is a VGR land, notice can be issued under section 18.2 of the Assam Land and Rule 18.2 of the Assam Land and Revenue Regulation 1886. So be that as it may, lays the case on so and so. Till then, there shall be status quo as regards. No, there shall not be any coercive action against the petitioners. In terms of the notice dated 11/3/2025 issued by the respondent number 3.
Deep.
We'll observe, try to find the Sita.
Yes.
That will make the position clear.
We'll try to.
The pattas which are given by the answerable, that is also 2010, 2017.
At least their entry was legal. Continuance may be illegal.
Item 2. In this case, my lord, the respondents, my lord, have failed to perform their statutory obligations, my lord, in accordance with the law. My lord,
What kind of statutory obligation?
My lord, what has happened in this case is, my lord, the petitioner is, my lord, an old lady, aged about 75 years. Now, she has been, my lord, tortured by her, my lord, daughter.
Mr. Sen, before that,
Physically assaulted.
before that, one more.
My lord.
Before that, we'd like to refer to the order dated 1/4/2024. Because you have sought also relief under Mental Health Care Act.
Correct.
And this court has already observed that said act has already been repealed.
My lord.
Then petitioner shall make necessary correction in their writ petition
My lord.
before the concerned section.
My lord.
Right. Did you carry out those?
Yes, my lord.
What kind of correction the court had ordered?
My lord, at cost title, my
Corrected
lord.
copy.
Cost title, my lord, page number 2. And then, my lord, page number 14.
14 and 14A received. Okay. Now, what are the prayers?
Prayers, my lord, that I have specifically, my lord, stated, page 15, my lord. A writ in the nature of mandamus shall not be issued directing the officer in charge, Chanmari Police Station, Guwahati 3, to register the case under section so and so IPC. Based on the FIR dated so and so, FIR dated so and so, and FIR dated so and so, lodged by the petitioner and for investigation the case in accordance with the law. Next, my lord, the writ in the nature of mandamus shall not be issued directing the respondent authorities to act in accordance with the law under section 20.
Mental Health Act or Mental Health Care Act?
Mental Health Care Act.
That is repealed.
That is repealed.
So prayer B is redundant.
My lord, A and B, A is, my lord,
No,
relevant.
prayer B is redundant. Prayer B.
B is not pressing, my lord. We are not pressing.
Not pressing.
Yes.
So after these FIRs, all these FIRs,
My lord.
did you approach the superintendent of police?
My lord.
Did you?
Yes, my lord.
Okay, let us see.
My lord, representation, your lordship will find page 37, my lord.
Page?
Page 37, annexure 6.
That is Director General of Police. And that is under section 23B. When a statute says that an act is to be done in a particular manner,
My lord, thereafter, my lord, we have by registered post with AD.
Where?
We have, my lord, made a complaint before the superintendent of police.
Where?
My lord.
Where? We don't find anything written to the superintendent of police.
My lord, it was there, my lord.
It was there, but in our file it is not there.
My lord.
At least that much is clear.
But annexure 6, your lordship will find, my lord.
What we can find
My lord, this
from
is, my lord,
Annexure 6?
this is
That is
fine.
an application under section 23B of the Mental Health Care Act.
That is there,
And
my lord.
under a repeal act. Why should an authority
My lord.
will act in a matter
My lord,
for a repealed act?
paragraph number 2 of that representation.
No, under your application is under Mental Health Act.
That's correct, my lord. But
That's
it is not
correct.
a-
When a repeal act,
My lord,
Mr. Sen,
my lord.
if it is a repeal act, no more consideration is required.
My lord,
And
yeah.
plus, where is your, for prayer A,
My lord.
where is your application before the superintendent of police?
That, my lord, I will place before your
No, no.
lordship, my lord. My lord,
You
I'll-
prefer?
My lord,
Now this has become more stringent now.
my lord, your lordship kindly consider, my lord.
No.
I don't know why police not registering the case. and
Definitely,
taking
that is
action.
why you go to the superintendent of police.
Superintendent police, my lord, I have, my lord. I'll place it before your lordship on next Friday, my lord.
Not,
Let it be fixed on Friday, my lord. I'll file an additional affidavit to that effect, my lord. It is there, I have seen. my
okay,
lord.
then you have to go to the magistrate.
Then again,
If it is superintendent of police,
My lord.
you have done it. Go to the magistrate, file an affidavit. Now this new act has made it more stringent. Already decisions have come.
my lord, Sikari Basu is there.
Not Sakari has been developed and more stringent now. At least 2 judgments. Sakari says repetition of this kind is to be thrown at the initial stage itself,
Oh, my lord,
not to be entertained at all.
my lord,
And now the
It says-
provisions, BNS provisions have been explained.
156.
Don't,
yes.
156 has been now
Yes.
175. Now it is more stringent. 2
Yes.
decisions have already been rendered by the Honorable Supreme Court on 175. Read with 156.3. Pursuing this remedy,
My lord,
if you come with superintendent of police,
my lord.
then I'll send it to the magistrate. Since 2024, last few dates, you have been doing it since April, 1st April 2024. I'm not going to entertain.
But I'll place that representation before Superintendent of Police, my lord, on
If
Friday
you have
next.
already placed before the superintendent of police, you have the cogent document,
My lord.
right? Then you approach the magistrate.
With that direction, my lord, with that observation, your lordship may dispose it of them.
I don't know you have the superintendent of police or not. We love the
That is why,
Sakai
that is
Procedure.
why, that is why.
Heard,
I'm.
heard, Mr. B. Kishin, learned counsel for the petitioner. And Ms. S. Kaur, learned junior government advocate Assam. For the response number 1 to 5. Also. এই mental health care concern, repeal করিলে. The petitioner has approached this court. Aru Sakari also, no? Has approached this court instituting the recent petition under Article 226 of the Constitution of India, seeking the following reliefs. Stroke directions. Page 17.
My lord, now, my lord, Mental Health Care Act 2017. Earlier it was repealed, my lord, now it has come into force since 2017, my lord. Section 154, 155, 156 and section 100 of the Mental Health Care Act 2017.
So far as Mental Health Care Act 2017, you make the, if you find that it is still maintainable, you prefer another repetition.
My lord, that is
right.
that is why, my lord,
Insofar as the prayer regarding the direction under section 23 and section 24 of the Mental Health Act, 1987, this court has observed in the order dated 1/4/2024 that the Mental Health Care Act 1987 has already been repealed. And the petitioner was directed to make necessary correction in the writ petition. First off, though some corrections have been made by the petitioner, there is no correction made with regard to prayer B, quoted above is concerned. First off, the case of the petitioner is also to the effect that the petitioner had submitted first information reports before the officer in charge, Chanmari Police Station, on 23/12/2021, 6/5/2022, and 22/01/2024 respectively. But the officer in charge, Chanmari Police Station, did not register those FIRs to commence investigation into the offenses which, according to the petitioner, are cognizable offenses. Full stop. Para. এইটো নহয় লিখক 18 লিখক para 18 para 19 no সাকারে বসে দিও মঙ্গল সাকারে বসে দিও From the provisions of the from the provisions contained in section Code of Criminal Procedure 1973, more particularly, section 154 and 156 thereto. It is discernible that if a person has a grievance that a police station is not registering his stroke her FIR under section 154 CRPC, then he stroke C can approach the superintendent of police under section 154 within bracket 3 CRPC by an application in writing, full stop. If that does not yield any satisfactory result in the sense that either the FIR is still not registered or that even after registering it, no proper investigation has been conducted, it is open to the aggrieved person to file an application under section 156 3 CRPC before the learned magistrate concerned, full stop. If an application under section 156 3 is filed before the magistrate can direct the FIR to be registered and also can direct a proper investigation to be made, in a case, where according to aggrieved person, no proper investigation has been made. The magistrate can also, under the same provision, monitor the investigation to ensure a proper investigation. First of para. Para 18 লিখিব, para 19 লিখিব, para 21 লিখিব, para 22 লিখিব, then para 22.1 লিখিব, para 23 লিখিব, para 26 লিখিব, after making an analysis of the provisions of section 156 3 CRPC and section 175 BNS, no, 175 the Honorable Supreme Court in Om Prakash Ambedkar versus the State of Maharashtra and others, 2025 INSC 139 has observed as follows. Para 24-25. After making an analysis of the provisions contained in section 156 CRPC and section 175 BNSS, the Honorable Supreme Court in Om Prakash Ambedkar Supra has proceeded to observe as under 29, para 30, 31, 32. 32 গোটেইখিনি নালাগে। The same position is also reiterated. আৰু এটা আছিল না? In a subsequent decision in নহয় নহয় এইটোৰ লগত এটা কথা আছিল এইটো নেকি এইটো নহয় সুপ্ৰিম কোৰ্ট এইটোৰ লগত আৰু এটা আছিল লগতে আপুনি লগতে আছিল কালি অ'কে এটা লাইন ৰাখি দিব এটা লাইন ৰাখি দিব ৰিচেণ্ট ডিচিজন লাষ্ট উইক অলছো same decision 175
Reiterated.
Reiterated. In view of the above position of law, this petition is not entered in, reserving the liberty to the petitioner to approach as per the provisions contained in section before the appropriate authority and stroke or the jurisdictional court, as the case may be, in terms of the provisions contained in section 175 BNSS.
156 Millard earlier because it was filed prior to Millard. The
Right.
businesses came into force.
156.
156.
Section 154/156 CRPC read with section 175 BNSS.
Correct. Highly obliged.
Item number 11.
Yes. Have you gone through this?
No, your lordship.
Another judgment actually very short. Because
Graveyard.
Lordship,
nothing down. That is
lordship,
nothing
may take it up day after tomorrow, your lordship. I will go through all these judgments and come up with.
Okay, under prayer of Mr. S. Bottakul and counsel for the petitioner released the case on Wednesday. Mr. C. Borual and standing counsel NHAI for the respondent number 1 to 6 has submitted that in respect of the plots of land in question, a notification under section 3D has already been issued of the National Highways Act has already been issued, wherein the plots of land covered by the DAG number 228, 228 and 229 are covered. Place the case on so and so. Occasion accordingly.
Item 17.
Subsequent decision লিখিলো হৈছে subsequent decision to the বৰুৱাই যে দিছিল item
17.
I was supposed to have instructed.
yes
It is not online, madam. It is physical application.
okay Mr. Mozumdar is not there so it is since it is acknowledged we can
Notified service, but there is no such thing in uploading the thing in our website.
okay then we can proceed to dispose of this petition right okay Mr. FZ Mozumdar and counsel for the petitioner MS M. Bormal and Junior Government Advocate Assam for the state responses are present. First up, Mr. MS Bormal has submitted that he has received the necessary instructions. Release the case on Friday.
I have written instruction. Should I have?
Yes, you can get it if possible.
Otherwise, they have stated that it is.
That's
under
okay.
process.
That's okay. No point keeping it pending.
Production list, item number 1.
Okay, Mr. Esbor and Lex letter will be taken.
Lex.
for impeachment of party, item number 24.
Made with your lordship. Lordship, I have filed one objection on Friday, lordship.
Already filed,
Probably there is.
not on record. Okay, Mr. M. Hussain, learned counsel for the applicants. Who is for the petitioner? Mr. P. Bordeloi,
Lordship.
learned counsel for the opposite party number 1, that's read petitions. Heard, huh? Mr. Bordeloi has submitted that he has filed an objection
Lordship.
to the instant interlocutory application, and the said objection is not on record. Post stop. He has thus sought listing of the case on another date. Post stop. List the case or office to trace out the objection filed by the opposite party number 1, that's read petitioner. And thereafter tag the same with the case records of ISC 482 2025. Post stop. List the case on Monday.
Obligation. Interim order.
The interim order passed earlier will continue till the next date of list.
Corporation Department.
Okay, Miss.
And Cameron representing MP Bola, starting cost. Comment number 2, 3, 4, 6, 7.
Next.
Obligation.
My lord, only thing then, my lord, next Monday there may be Eid or
Huh?
there may be a Eid,
Oh.
my lord.
2nd of April. 2nd of April.
Obligation.
Item 26 for admission.
May it please your lordship.
Adjournment one আছে জানো?
But here in this case, what had happened, my lord, due to widening of the road and construction of a drain, some portion of my land was, my lord, had entered into that. Lordship may be kind enough to peruse the order dated 19/2.
19/2, 2000?
19/2, 2020.
Oh. PWD.
Yes, ma'am. Last paragraph may be seen, my lord, it was observed that let the work progress and at the end the land may be measured. And if something is there,
Where is Mr. Gogoi? Names are reflected or not? Who appeared earlier? Mr. B. Gogoi.
initially Mr. Dhar had also appeared, my lord. R. Dhar.
Where is Mr. Dhar or Mr. Gogoi? This court is in view of the nature of claim made by the petitioner, joint measurement was directed by this court.
Joint
Same-
measurement was carried out, my lord.
That was done, lordship, by way of an affidavit that we have placed.
Now, as per the Jamabandi, it was my land is 4 katha 18 lechas. Now from the joint measurement, it turns out it is 4 katha 15 lechas, man.
3 lechas.
3 lechas less.
That is, that your lordship will get
Page 24.
page 24 of the affidavit filed by the respondent number 3.
Affidavit filed by?
Respondent number 3. As your lordship was. Annexure A, page 24, running page.
And what is the case of the petitioner?
Only the compensation part, man, for the 3 lechas.
No, you have how much land?
4 kathas 18 lechas, my lord. The
Where
Jamabandi,
from it is
the
reflected?
Jamabandi is a part of the writ petition, my lord, page 14.
the English translation starts at 11, my lord. The noting is at my.
Yes, Mr. Chaudhary. He says, petitioner says 4 katha, 18 lesser. Joint measurement was directed 4 katha, 15 lesser. Apparently, it goes inside the road. No affidavit.
Yes, yes, my lord. I have not received any affidavit, any instruction. Lordship.
But court has been repeatedly
Matter of 2020.
observing that affidavit of the respondent number 3 and 4 should be filed without fail. And Dibrugarh town, 3 lessers, market below.
Yes.
It will fall upon you.
Lordship, 1 week then, Lordship, I'll get the instruction. 1 week, Lordship.
Now a report is there already.
Yes.
And it is carried out in presence of officials of PWD roads. Now buck may stop at you.
Lordship, last time, so 1 week then.
2020 matter. Okay, heard Mr. Neka. No, counsel for the petitioner. Mr. B. Chaudhary. Standing counsel, PWD for the respondent number 1 and 2. And Mr. H. Sharma, learned additional senior government advocate Assam for the respondent number 3 and 4. Post of the petitioner claims that he is the owner of a plot of land measuring 4 kathas, 18 lessers. And in support of the sale back, comma, has referred to the Jamabandi annexed as the annexer Roman 1 to the writ petition. Post that the petitioner has further contended that while constructing a drain or what? Drain. The respondent PWD authorities had encroached a part of the petitioner's periodic pata land. Post of this court by order dated 39/2024. Come ahead directed the respondent authorities to carry out. No, 8/1/2021. Joint measurement in presence of the petitioner or his authorized representatives. Post of the respondent number 3 has filed an affidavit in opposition on 27/2025, annexing a copy of the joint copy of the report prepared after the joint measurement. Post of as per the joint as per the said report, comma. The petitioner is in occupation of an area of land measuring 4 katha, 15 lessers within DAG number 510 and periodic pattern number 297. Post of para. A question would arise as regards the remaining 3 lessers of land under DAG number 510 and periodic pattern number so and so. Mr. Chaudhary, Land Standing Council, PWD, has sought for and is granted a week's time to file an affidavit in opposition on behalf of the respondent number 1 and 2. Post of Place the case on so and so. The respondent number 1 and 2 shall ensure that the affidavit in opposition is filed on or before the next date of listing. 23rd. Okay, 23rd. Since it is an admitted position. Okay, 2 weeks time, we'll put it.
Item 27.
GMC were to file an affidavit, my lord. And the.
File.
No,
Should actually require some more time.
More time.
See,
Okay.
the elections are inactive, so it's taking us a bit of time to translate.
Sir Edas.
Edas.
Heard. Mr. Porter petitioner. A. Botakur. H. Borua. Land Council representing Mr. P. Nayak. Land Standing Council. ZDD. Stroke ZMC for the respondent number 1, 2, and 3. And Mr. B.J. Taludar, Senior Counsel, is stated by Mr. P.K. Medi, Learning Counsel for the respondent number 4 and 5. M.S. Borua has appearing for the respondent GDD stroke GMC has further has paid for further. How much time? Okay, 3 weeks time to file a counter affidavit on behalf of the respondent number 1, 2, and 3.
And my lord, there was a direction.
Huh?
There was a direction to produce a letter, my lord. Last order date 3-3, my lord. Down below your lordship will find.
Yes. There was a direction to produce a letter. 29/4/2022.
Yes.
What is para 9 of the affidavit in opposition
this
filed
is a
by the
letter-
there is a reference to a letter of the commissioner requesting the GMC to provide police force. Okay, request the commissioner for the purpose of maintenance of law and order. Okay.
Then-
So some order was passed
Yes,
there.
because, yeah, because
Okay, okay.
the GMC authorities, they had demolished, my lord. And in fact, that your lordship's order was there in the writ petition that some time was given. But within that time, they have demolished it. And now they say that the GMC had requisitioned the police force, but they have not annexed it.
Undertaken to place. Already undertaken. Assured, meaning thereby.
It was communicated by.
Mr. Taludar, the senior counsel appearing for the respondent number 4 and 5, has also sought 2 weeks time to produce a copy of the letter number so and so dated 29/4/2022. Order to likha ase letter number to sign. Okay, list the case. Definitely after go, it will go after me. List the case on so and so.
28. Item 29.
Publish.
May I please your lordship? Lordship may kindly pass over a matter for time being. My senior is on legs in court 6.
No, madam, it will be timing will be very difficult.
The date may be fixed, lordship.
Okay. On the prayer of Miss so and so.
D. Bora. Miss D. Bora.
Release the case on next week. Appeal or Duke. First week.
Item number 30.
May I please your lordship? Lordship, in this matter, on the last occasion, Mr. B. Talukdar prayed for 3 weeks' time to file their
Pending
affidavit.
also elementary education
Yes,
department.
elementary education.
What elementary education has to do here?
They have to file their affidavit, lordship.
They have to file their affidavit. Land grabbing.
Yes, lordship.
It used to be registered as CRP only. Huh? You go through the decisions of WPC number.
4226.
You did. Abad Ali.
No.
Huh? No. I only held that land grabbing tribunal judgment and order is a district judge. So no writ petition. WPC number to WPC number 558 2024. Judgment and order dated 27 to 2024. Right? Have you written?
Yes, Lordship.
Go through it. Miss
P. Kaklari.
P. Kaklari.
P.
B. Kaklari. Heard Miss B. Kaklari, London Council for the Petitioners. Miss Kaur, you represent?
4 and 5, Lordship.
Okay. Miss Ascor and Standing Council. Elementary Education. Department for the respondent of 4 and 5. What about these private respondents? The Learned Council for the Petitioners shall address on the point of maintainability of a writ petition under Article 226 of the Constitution of India to assail an order passed by the land grabbing. So, but it is some. Tribunal ko eta kiba ta koy. Passed by the passed by the Court of Additional Session Judge number 2, Nagaon, in his capacity as the special tribunal within bracket land grabbing under the Assam Land Grabbing within bracket Prohibition Act, 2010 as amended. Lays the case. When? After a week.
After a week.
Lays the case on so and so, April.
Deeply obliged.
Item 31.
May I please, Your Lordship? In this case, Lordship, they are supposed to.
I have
file
directed
affidavit.
to maintain status quo. Because of software provider. The respondents.
No, affidavit.
Who are the respondents?
My Lord, Revenue Department, Lordship.
Revenue.
My Lord. Including Lordship, Chief Executive Officer.
Anchalik Panchayat. Who is that? Panchayat and Rural Development?
Lordship.
31. Yes, PNRD. Who is required to file the affidavit?
My Lord, this, we have challenged the order.
Panchayat Department or
Circle
District
Office.
Commission?
State, Lordship.
State.
Lordship.
Okay.
Jail encroaching government apart from the allotted.
Heard Mr. M. Khan. Learned Counsel for the Petitions. PR Mohanto, Revenue 1. BJ Talukdar, Learned Senior Counsel, assisted by Mr. P.K. Medi for the respondent number 2, 4, and 5, 6. Miss P. Thapa. B for Punjab. Thapa. Learned Counsel representing.
3 and 7.
You are standing counsel. K?
Poor.
War. Okay. That's standing counsel, Panchayat and Rural Development Department for the respondent number
3 and 7.
3 and 7. Post of. The respondent number 2, 4, 6, 5 and 6. And the respondent number 3 and 7 shall file their counter affidavits. No. And so in order to adjudicate the issues raised in this petition, comma, and counter affidavits on behalf of so and so appear necessary. So Mr. Talukdar, sitting counsel appearing for so has submitted that he has received the necessary instruction to file the counter affidavit on behalf of the so and the same would be filed within a period of 3 weeks. He has thus sought for listing of the case after 3 weeks. MS Thapa, learned counsel appearing for the respondent of so has also paid for and is granted 3 weeks time to file counter affidavit on the poster. List the case after 3 weeks. On a day 2 weeks by the office, the interim order past status will continue till the next of list.
Production list, item 1.
May it please your lordship, my lord petitioner before your lordship, they are my lord road sweepers, Mazdoor and my lord handyman working as an employee in GMC your lordship. What has happened my lord in the year quarter?
These are employees.
Employees of GMC employees. Working as road sweepers my lord, Mazdoor, handyman, etc. your lordship. My lord, in 2022, what has happened your lordship? The quarters which were allotted to us, my lord, got fire, your lordship, and everything was, my lord, burned. So, as a, my lord, interim measure, authorities, they have provided us, my lord, quarters. In, my lord, New Harijan colony, your lordship. Accordingly, we are residing in that quarter, your lordship. And, my lord, thereafter, your lordship, some of the other similar situated persons, my lord, in 2013 approached this honorable court saying that quarters have not been allotted to them because 252 quarters were constructed out 352 out of 350 to 319 quarters were allotted to these employees, my lord. There are anomalies in allotment of those quarters, my lord, because in some cases, husband and wife both were allotted. In some cases, the person he is no more. So one committee was constituted to examine, my lord, verify the actual position of those quarters. But that committee, my lord, has not, after constitution of that committee, my lord, nothing has been done. All of a sudden, my lord, that your lordship will find at page 79, these impugned orders were communicated, my lord, last week or, my lord, last to last week, your lordship. Last week also, my lord, page 79 onwards.
But there is a set of litigations.
My lord, the order passed by this honorable court 106. My lord.
Set of litigations already.
My lord,
decided.
No, my lord, we are not party to that.
Maybe.
And my lord, in
who is the judgment?
Judgment 106, nowhere said, my lord, that I should be vacated. We have already occupied, my lord. Kindly see our plight, your lordship.
What is the order there?
The order page 106 and operative portion starts from 116. My lord, after 5 years also, my lord, if we go, nobody is giving us a house on rent, your lordship.
No, the question is also really connected with her judgment.
Connected,
right?
but this.
Let me find out.
Mine.
Now, what are these notices?
Notice same date, my lord, 21/1/2025, received recently, my lord, last week. Page 79.
What is the content?
Content, my lord, page 79, my lord, kindly see. Notice to vacate the temporary accommodation at Fatasil New Horizon Colony, whereas a devastating fire incident broke out at Horizon Colony, Fatasil on so-and-so, which completely gutted many houses, affecting many families thereby. Whereas an order was issued by the then Deputy Commissioner and Chairman District Disaster Management Authority, computer so-and-so, requisition number of 33 numbers of sealed and sub judice quarters of GMC, New Horizon Colony, Fatasil, for temporary accommodation of the fire victim families under the provision of so-and-so. In reference to the said order dated so-and-so, issued by District Authority, a committee was formed by the Commissioner so-and-so for making necessary arrangement of fire victims in 33 numbers of so-and-so dwelling unit at Fatasil, New Horizon Colony on purely temporary basis, with an undertaking that the concerned allottee has no objection with regard to such temporary allotment, and they will vacate the temporary accommodation as and when required by Commissioner, Guwahati Municipal Corporation thereafter. Whereas 3 numbers of writ petitions bearing number so-and-so were disposed of by Honorable Guwahati High Court by order dated so-and-so, and to give effect to the said order, the undersigned deems it necessary to take back the possession of so-and-so dwelling units at Fatasil, New Horizon Colony from the present temporary allottee in consideration of the order dated so-and-so, as in so-and-so undertaking given by each and every temporary allottee, you are directed the concern to vacate the present so-and-so within a period of 30 days from the receipt of the said notice and give peaceful possession of the same to the GMC authority. My lord, after the fire, we have been assurance we are given that they will accommodate us in another quarter, your lordship. And my lord, this is the order passed.
So,
Before
well,
that,
so far as this,
no notice, my lord, is given to us.
no notice is one thing,
My lord,
but so far as your right to occupy
my lord,
these the quarters, or this what is called BSUP or what
this
is
is
whatever,
grade 4.
whatever BSUP.
Grade
so
4,
and so.
4 quarter, your lordship.
No, it is because I had the occasion also to deal. So, what is that BSUP? Something like that, right? Huh?
Scheme.
Ha.
JNRM.
Ha. So, to occupy this quarter for indefinite period is for
True, your lordship. What I am saying,
now, there is another thing that you need some breathing space.
my lord,
To move outside the quarter is the only issue here.
my lord,
Because you have no right at all to occupy these quarters.
my lord, this was allotted to us temporarily basis. Absolutely.
Temporary, and they have
My lord,
those others who are also now homeless.
my lord, what I'm saying, those others, for that committee was constituted. And this honorable court never said that you...
No, mister, you don't try to
My lord,
get a permanent right here. Now
my
tell
lord,
me,
if-
what is the period you need?
my lord, what I'm saying, unless until they will not provide us, my lord, accommodation, because, my lord, I am working as an employee in GMC, and nobody, my lord, give me...
No, so far
house.
that is another. Don't try to
My lord,
don't try to
otherwise I-
put the both
Otherwise, I am...
things together
My lord, otherwise I am entitled...
claim occupation of these
My lord, otherwise...
quarters.
True, my lord.
This
Otherwise,
is quite clear that it is for temporary.
otherwise, I am entitled for that, your lordship. Number one, earlier, before fire...
That I
was-
don't know regarding that.
Before
that part.
fire, my lord, quarters were allotted to us, and we have been given assurance that 70 numbers of quarters are being constructed. So they will accommodate us in those quarters. So far as 352 quarters are concerned, my lord, 319 quarters.
352, I think judgment will clear how many have been occupied or how many were there.
Still vacant.
Someone try to page number.
Because we try to.
141.
Huh?
Course of hearing. Paragraph 9, it will make it clear. 141, page 141.
We are not party to 141.
141, page 141. Oh, sorry, 114, my lord. Paragraph number 9. Because
This is the PSCB house, 33, there are 33 petition in the all the three petition, 33 houses are kept vacant.
This is the situation.
Then they had to place, they were put in
Exactly 33.
33, they were put in after then the undertaking was taken that if whatever the result of this rent petition, we'll have to vacate it.
My lord,
that
so far
I
as
have
the
taken notice.
result also, my lord, this honorable court without examination verification, my lord, because I will place before your lordship in one family
Tell
has
me,
been given
Mr.
2
Goel,
quarters.
hard time you need.
My lord,
This is already a judgment already.
my lord, this judgment is not against, number one, I am not party to this judgment. Number
No,
two,
do you claim a permanent occupation of these 33? Tell me.
my lord, I am implied they have to provide me
No,
accommodation.
this has already been considered in the other batch of writ petition.
I am not,
No,
in
tell
the-
me what is this?
my lord, I am not in party to this petition.
That is a different thing.
Because earlier it was allotted to us.
That is a different thing.
Being an employee of GMC, they allotted us quarter, your lordship. This is
So
not,
is it these quarters?
My
These
lord,
33 quarters?
my lord, this 32 was given because of the fire. Now 70 quarters, they are.
That is, don't mix up 33 with 70.
My lord,
Don't try to mix up.
my lord, I am ready to vacate.
No, this
provided they
79 notice, page 79 notice, in the notice, it is clear that 33 sealed and sub judice quarters were requisitioned by the district commissioner as a chairman, district disaster management authority because of the fire. And exactly 33 was in litigation in the batch of writ petition, which was pending since 2013, right? And ultimately, the direction has been given for consideration of these 33. So you cannot claim, if you are in the waiting list of those, you can claim.
What I'm
But there was a list in those litigations.
My lord, what I am praying for your lordship. Otherwise, I am entitled for quarters for my accommodation.
Yes,
My
that issue, but
my lord, this is the assurance, my lord. If records may be called for, this is the assurance that alternative arrangement will be given. In that
until
case,
that time, you will be allowed to occupy this.
in fact, they are constructed.
But people are, other 33 families are also without
My lord,
quarter.
70 quarters, it is.
That's
why I am saying.
But
They
what
accommodate,
about
I
this?
will vacate tomorrow, my lord. If they allow us to shift in those quarters.
This was in January 2025.
My lord, recently we have received, my lord. All are sweepers, my lord. What are you?
Oh, when it was served, Mr. What is your statement? When it was served?
Recently I have become, because 26.
When it was served?
My lord, somebody is saying when he was not at home, it was pasted. Somebody is saying it was sent.
It was pasted in the particular area.
My lord, this is the difficulty, my lord. Somebody was not here. Somebody was not here, your lordship. They are.
And whether they have any quarter?
Yes, my lord. Before fire, quarter was there, your lordship.
Whether repairing?
It's a different issue. When that particular took fire in a different place, and this is from Patasila.
It was took place in old Harijan colony, GMC colony.
No, don't mix two things. These 33 quarters were meant definitely for temporary.
True, my lord.
Don't try to claim
True, my lord.
occupation there for permanent.
I will
nature.
vacate, my lord, tomorrow itself. If they
No,
provide us
no.
70.
What kind of fire broke out and how?
Entire, my lord, got it out, my lord.
Huh? Got it?
Nothing.
But at that particular situation in December 2020, fire broke out. They were shifted from that particular place. and
Entire
shifted
thing
from
was.
another place. Then vacating period.
Some organization came, my
was-
lord. They have distributed food and all.
I was filed the main petition, my lord.
That was in 2022.
22.
Uh-huh.
Then they were put in this 33 litigated space, my lord, and they gave an undertaking that they will
Right.
get it. That's why.
That's what
Then-
that undertaking was given subject to.
Whether any alternative
That instruction I don't have it.
measures you have taken or not to
that
accommodate them.
But that instruction I don't have it right now, my lord. What at the place where these people were staying, that where fire has taken place in the month of December 22. That instruction I don't have.
Right. It was in 9th December 2022. You made them to stay on and from 2022.
After the order of the court, my lord. This I was filed for allowing them to stay because they can.
No.
Okay, whatever. Since December 2022, you have accommodated these families in 33 sealed and sub judice quarter. So perhaps with thinking that you'll accommodate in due course in some other alternative accommodation or not.
That-
What
at
kind
that
of
part- at-
decision
at
you
that
have
part-
taken?
At that particular point of time, Lord, these 30 there were 33%, 33 BSC houses empty because of this litigation. And I was filed in the main case that to allow this 33.
No, I understand. No.
And they also gave an undertaking that.
I understand to that extent.
And
Now, after this, their quarters were gutted in a fire incident in December 2022. And while accommodating them for temporarily in these 33 quarters, whether you have taken any alternative measure to find out alternative arrangement for them or not,
That I take instruction, that I don't have it.
you take that instruction at least. Don't take, if they are not evicted, then don't evict now. Till then, take instruction. Two,
Well,
3
I'll take
days,
instruction.
2-3 days at least you can take instruction.
Lawsuit posted in 10 days. Lord.
Heard Mr. Egwell, counsel for the petitioners. How many petitioners?
27.
And Mr. S. Bora, standing counsel, GMC.
1, 2, 3.
Also ZDD,
Yes, Lord. 1,
ZDD, stroke, GMC. For the respondent 1 to 4.
3 and 4.
1 also, ZDD,
1, yes, my lord. 1, 2, 3, and 4. Up to
4. And Mr. BJ Halder. Senior counsel assisted by Mr. PK Medi. Counsel for the respondent number 4.
5, my lord. 5.
5. So the petitioners, 27 in number, have claimed that after an fire incident, breaking out in a fire accident, breaking out at Horizon Colony Fatasil on 9/12/2022, completely gutting out many houses, have submitted that a fire incident broke out at Horizon Colony Fatasil on 9/12/2022. Full stop. In the said devastating fire incident, many quarters were gutted out. Most of the petitioners at that point of time, were staying in GMC quarters. GMC quarters.
GMC old Horizon colony.
GMC quarters at Horizon Colony Fatasil, and their quarters were also gutted out in the said fire incident. Full stop. By an order dated 20/12/2022, the respondent of 5 requisitioned 33 number of seal and subjudice quarters of GMC at New Horizon Colony Fatasil for temporary accommodation of the fire victim families, including these petitioners. Post of. The petitioners have approached this court after they have been served with a notice to vacate. Notice dated 21/01/2025 to vacate the temporary accommodation provided to them at Fatasil New Horizon Colony. Post of Mr. Bora, standing counsel, GMC, has submitted that with respect to the 33 number of quarters of GMC, there was a series of litigation which culminated in a judgment and order Series of litigation in the form of WBC number so and so, WBC number so and so, and how many? Three. WBC number so and so, which culminated in a judgment and order
310.
dated 3/10/2023. Post up. In the judgment and order dated so and so, comma. It was submitted on behalf of the respondent ZMC that 33 flats were kept aside at New Horizon Colony for allotment, and due to the fire incident, comma, those 33 flats were in those 33 flats, comma, fire victims from the incident dated 9/12/2022 were temporarily accommodated, and with an undertaking that those 33 flats would be vacated immediately after a decision taken in the proceedings in WBC number so and so, WBC number so and so, and WBC number so and so. And stop. It is after the judgment and order dated 3/12/10/2023. The notice dated 21/1/2025. Notices have been issued to these petitioners who are occupying the 33 flats. Among those 33, number of quarters at Horizontal Colony. Mr. Goel, the counsel for the petitioner has submitted that, while in the fire incident dated 9/12/2022, at that time the fire incident broke out, the petitioners who were living in GMC quarters, and since in the incident dated 9/12/2022, their quarters were gutted, were damaged fully. The petitioners, the respondent GMC authorities are duty-bound to provide alternative accommodations to the petitioners in the meantime. Mr. Bora, standing counsel GMC, shall obtain instruction as to whether at a time of providing temporary accommodation to the petitioners in the 33 number of flats at New Horizon Colony, there was a corresponding undertaking made to provide alternative accommodation to these petitioners. Full stop. As sought for by Mr. Bora, placed the case on April 2nd of April.
Or after the vacation.
Let it go 9th.
9th of April, 7th of April.
No, my lord, except 7, your lordship.
Then 4th. I'll not leave it to the last date. Having regard to the projection made in the state petition, the respondent GMC authorities shall not act further on the basis of the notice to vacate dated
21/1.
till the next date of this.
My lord, it may be communicated with my learned friend communication.
Mr. Bora, the standing counsel GMC shall communicate the contents of this order to the competent authority in the GMC during the course of the day.
Deeply obliged. Item number 32.
But please, Your Lord, that's why I am appearing on behalf of the respondent of 4 and 5. I want a 3 weeks time to file affidavit and opposition.
Your Lordship, on the last occasion on 1/10/2024, it was, by this honorable court, it was ordered to issue notice to respondent number 4.
Now they have appeared.
It should have come on orders, Your Lordship, but it came for admission.
Huh?
It should have come for orders, I think, Your Lordship.
Orders now and they have appeared, I think.
Yes. Your Lordship, it would be kind if the matter can be taken up before Bihu, Your Lordship.
He is seeing the first time he is appearing. Heard Miss
B. Soren, Your Lordship.
B. Shoren. Learned counsel for the petitioner. Social welfare? Anybody? Mr. A. Sharma, learned junior government, senior, additional senior government advocate, Assam for the respondent 1, 2, and 3. So, Mr.
M. Das.
M. Das, learned counsel has submitted.
I cannot say director, senior citizen, welfare council, I not know.
1 and 3. Then.
1 and
Who is this authority here? Welfare Council? So and so has submitted that he has entered appearance on behalf of the respondent number 4 and 5. And has further submitted that the affidavit in opposition on behalf of the respondent number 4 and 5 will be submitted within 3 weeks time. He has thus sought listing of the case after 3 weeks. Okay. The prayer made on behalf of the respondent number 2, 4, and 5 is accepted. Lays the case after 3 weeks. The respondent number 4 and 5 shall file their affidavit in opposition within the next 2 weeks without fail.
Obliged, Your Lordship.
33.
May it please the Lordship. Regarding Lordship issuance of OBC certificate, they have filed their affidavit in opposition and we have filed our reply also, Lordship. We have applied for OBC certificate, Lordship, that was rejected, reverted back, rejected 3-4 times.
3-4 times, then we'll admit the writ petition.
But
3-4 times, then we'll admit the writ petition.
Lordship, sometimes
No
they
way.
are asking for some documents, something their Lordship, always we are already provided all the documents, Lordship. Irrespective of that, Lordship, they are saying that
3-4 times, then
Lordship only
there is no concept of rule or what? We'll
Lordship,
issue rule here.
already father was given, Lordship.
Okay, we'll decide.
Sister was also given, Lordship.
Yes, affidavits are filed.
Yes, Lordship. Only they are taking a stand that as per 20.
Okay, we'll issue rule.
Lordship, but I have urgently as a student, Lordship.
Court has the discretion.
Lordship, that is up.
Who are you? What you are studying?
Lordship, higher secondary, 2nd year, Lordship.
Huh?
Higher secondary, 2nd year, Lordship. I am represented by my father, Lordship.
Okay.
First year. Higher secondary, 1st year.
What's your in the list? Miss R. Chaudhary.
On the very first date, your Lordship was about to dispose of the petition, Lordship, giving liberty to the petitioner to apply afresh and thereafter to direct them to.
Okay. Social justice, who are social justice? Miss D. Jain. Your standing counsel. Already filed your affidavit. Huh? Is it necessary or not necessary?
Necessary, Lordship, already the affidavit filed by respondent.
That will be sufficient. Please tell me, I am not applying my mind.
By the respondent number 2.
Some backward classes.
Some backward classes commission.
But Lordship, already they have taken a stand that Lordship, my father is a certificate was already granted.
They will have to say, madam, that we cannot say.
Yes, madam. Who is to there?
Who is
Assam Backward Class Commission.
Who represents?
whether notice is out or not?
That I don't know.
Notice, Sir Lordship, we have on the very first date, your Lordship has issued notice. On 23/9/2024, Lordship.
But as Borua,
I think our is.
that day, Mr. S. Borua, government advocate, has accepted notice.
How can be? Because he is not a.
Our Chaudhary petitioner. On the next day also he accepted. He appeared. Now,
And Lordship may.
on the next day also,
I'll ask, S. Borua is Mr. S. Borua.
Mr. S. Borua. Mr. S. Borua, perhaps.
Lordship may
He
take it up.
decide who represents.
May take it up after some time. I will.
Cannot, because government council cannot, because it's a.
Call Mr. Dhor and R. Dhor if he is available. Otherwise, again, it will unnecessarily prolong.
Lordship.
Because that's lordship, I'll take your lordship to the AVDB.
Okay, if you have said that, okay. Let Mr. R. Dhor be called.
Lordship, after some time. Obliged.
Item 34.
On the last day, Mr. Goswami said
Yes, my lord.
that he will file a counter affidavit.
Not filed. Some notification has also been issued by the lordship. I have not received the comprehensive, my lord, instruction to file the affidavit, my lord. And some legislative formalities are pending. So at this stage, that is the problem. And they are at liberty to question this if they wish to do so.
Whom to will question?
Involved.
It has not yet become law.
They also know all these things, my lord. In their petition, they have not stated anything as regards the same matter. And they cannot seek a direction from this honorable court to get their land registered.
But they have a right to get their application disposed of.
Yes, by the concern. But
They have made an application.
my lord,
Page 23, they
This
have
is the
made an
NOC.
application
NOC, my lord.
for NOC.
Yes.
It is a notified public service. And as per the statute, this has to be disposed of within a specified time period, either allowing
Sure.
or rejecting. If it is rejected, regions are to be recorded,
But core issue is this.
whatever.
This is the core
But
issue,
he has a right
my lord.
to get the notified service
Yes.
application for
Yes.
notified service
that.
either to be allowed or not to be allowed. If not to be allowed, regions are to be recorded. Then region can be tested.
Yes, that part.
Uh,
Whether the regulatory power of the state is there or not.
Then
that's
we'll
a
test.
larger issue to be discussed here. my lord.
But here,
Without.
here, page 23,
My lord. That is before my lord issuing this notification, my lord. the
whatever.
process That was there. my
But
lord.
he has a right under the Right to
I
Public
can't say
Services Act
anything, my lord, with regard to his right, because my lord.
to get the application disposed of. This way or that way.
And if they want to proceed further, my lord, certainly they have to question this, my lord.
No, they will question for provided you record the regions.
My lord.
In a
At
in
least-
a application rejecting,
At least, my lord,
That is-
before this honorable court, my lord.
you are obligated.
Yes, sir, that is always there, my lord.
You
But
are
in-
obligated to dispose of the representation within a stipulated timeline, either allowing or rejecting
Yes, yes.
application.
Yes.
While rejecting application, record the region where he has to prefer the appeal, then he will consider.
But, here is a question,
So if you say,
my lord, so far the decision of this honorable court will certainly be the final, my lord. Authority will have to.
no,
comply
we
with
are
the
at
direction
this
of-
stage, we are.
I am not on that. my lord.
Legislative this thing under process, so by an office memorandum, whether something,
Yes.
because
This has already.
this has to be related to the constitutional right under Article 308
that
and
one-
8 also.
Yes, my lord, that power is always with the state, my lord.
That
regulatory
will
power
say.
is, if that
No,
is allowed.
will
my
not,
lord,
no. I am saying that this, for the purpose of this repetition,
My lord.
let his application be disposed of.
Yes, that is there, my lord, in the second column, my lord.
Hmm.
Do no phrase petition since that is abundantly clear. my lord. That is why my submission is.
Because he has a right to know.
Right. My lord, ultimately, what will happen, that part I am submitting only.
That it is up to you. Get the order
Only thing, my respectful submission to your lordship, my lord.
that which can be tested thereafter.
Yes. Lordship, kindly refer this notification.
I'll make your this thing. I'll not give my approval to this. I'll not say anything.
Yes.
This may be vulnerable. I am not doing
Yes.
neither vulnerable nor putting in my approval.
But my respectful submission, my lord. State
I'll
has
say
this-
that there's some
that is
this thing.
always there.
There is an office memorandum so and so,
My lord.
but we'll observe
contempt.
without
My lord.
commenting on so and so.
Yes.
The petitioner has a right to get his application
Dispose of.
disposed of. Some right to public service.
By saying so, my lord, that will be disposed of, my lord.
Yes. Will not go into the merits of the application. Third, Mr. S.C. Biswas, Learned Counsel for the
Walperable because.
ভুল বলপটা
same.
সেম
But there, this is shown as Walpara district.
not গোয়ালপাড়া but wrongly written it is
All right.
বলপটা
Borpeta. Okay.
All right.
Right to public service, yeah, no?
ভিতরে দেখো না
Mr.
এই দেখো
Revenue Disaster,
My lord. Yes,
Oh.
he's there last time, my lord, as reflected in the order. Lordship.
okay. Mr. B. Goswami, Learned Additional Advocate General Assam, assisted by Mr. J. Hendrik, Learned Standing Counsel, Revenue and Disaster Management Department, stroke Junior Government Advocate, Assam, and Mr. P. Kakoti, Learned Counsel for all the respondents. Full stop.
He's advocate.
Learned Counsel, I have said. In this petition instituted under Article 226 of the Constitution of India. The petition. has projected that he is a joint pattada and owner of a plot of land measuring 1 katha, covered by DAG number 705, KP Patta number 26, situated at village Nangakusi Gaon, Mauja Kilajari, Borpeta Revenue Circle, District Borpeta, subject plot. Post up. The petitioner has further stated that the petitioner's son is presently prosecuting his study
At Nerin.
Of Master in Business Administration, MBA, at Nerim Group of Institutions at Guwahati. And in order to pay the fee for the MBA course, an urgent requirement of a huge amount of money has arose in order admission fees and other education expenses. So stop. The petitioner has therefore offered to sell the subject plot to an intending purchaser, and after arriving at an agreement to sell the subject plot, the petitioner submitted an application What is the service? For sale deed registration,
Yes,
stroke no objection certificate.
yeah, it has been issued to us.
Huh?
No objection has been given.
Mhm.
No objection has been given, madam.
No objection given.
By the Borpeta Development Authority.
Huh?
Borpeta Development Authority, Annexure 3, page 20.
Page 20.
Not by the sitting applicants.
A petitioner has been issued a no objection certificate for sale stroke transfer of land by the Borpeta Development Authority, constituted under the Assam Town and Country Planning Act 1959. First off, as the petitioner is also required to obtain also to get the sale deed registered.
For that purpose, I think by the
Sale deed registered to sell the subject plot, the petitioner, is it a notified public service?
Pardon?
Under the Right to Public Service Act, this deed registration. Yeah, deed registration to section 21 at a section 21 or at a section 21.
I'm pointing out, madam, the NOC that is by the authority, development authority, not by the deputy commissioner.
No, there is provision for that also.
Madam.
There is provision for that
Yes, yes,
also,
that is
and
there.
I have, that is
Both
why I have
both
said,
the authorities are required to.
that is why I have said Assam
Yes.
Contempt Planning Act. Now, this is a notified service or what? Section 21A. What is this page 24, Mr. Biswas?
24 months.
Hmm.
Is a pre-registration summary, madam. They have uploaded in the
Section 21A. Teacher should be on. The petitioner applied for sale permission, stroke no objection certificate. Before the response number 3 on 25/6/2024. By following all the requisite formalities and on receipt of the application, comma, what is this? Then page 18 already granted NOC.
yes, NOC granted.
Page 18 already granted on 29/5/2020.
18, page 18.
And
Annexure 2.
the response number 3 on 25/6/2024 issued no objection certificate for transfer of land by way of sale, etc., to the petitioner in respect of the subject lot. Full stop. After getting the permissions from the Borapeta Development Authority and from the response number 3, comma, the petitioner applied online for registration of the
Yes.
sale deed,
Yes.
along with the aforementioned NOCs before the district registrar.
Yes.
District registrar. And on 3/10/2024 and acknowledging the receipt of the application for deed registration, comma, the response number 3 has issued its acknowledgement, right? Acknowledgement number is 23. So and so 8966. While issuing the acknowledgement, comma, it is further mentioned that the petitioner may raise an appeal if the service is not delivered within 1 day. Full stop. The Office of the Deputy Registrar, Borpeta, has also generated a pre-registration summary incorporating the details for effecting the registration of the sale deed. Full stop. As The service of deed registration has not been rendered by the district registrar,
Yes,
district commissioner come district registrar,
he's holding both the posts.
Borpeta.
Perfect.
Within bracket, the response number 3, the petitioner has approached this court by the instant writ petition on 16/12/2024. Post of para. Mr. Goswami, learned counsel appearing for the respondents, have submitted that there are valid reasons behind not registering the sale with the petitioner by the respondent number 3 and the respondent number 4. First off, he has submitted that
First notification I submitted earlier. Take the papers.
by an office memorandum dated 20/01/2025.
The earlier to the 6/9/2024. Earlier state of my lord instruction I placed before election.
By office memoranda, comma, dated 6/9/2024
Yes.
and dated 20/01/2025, comma, certain restrictions have been placed in respect of lands falling in Borpeta town, in Borpeta district, in respect of lands within areas falling in respect of lands in areas falling within 5-kilometer periphery. Oh, sorry. In respect of lands are falling in Borpeta town, in Borpeta district. And it is in view of such restrictions,
That is
the sale deed submitted by the petitioner on 3/10
I think not send it back.
3/10
Eastern, madam, 5/10/24.
24.
Yes. Eastern.
That is page 23.
Yes, yes,
3/10/2024
yes.
has not been registered. Post of Mr. Goswami has further submitted by another office memorandum dated 6/3/2025. The restrictions placed in respect of
3 places.
registration of sale deeds falling in Borpeta town, Borpeta district. Restrictions in respect of land, comma, as earlier, comma. In respect of Borpeta towns in Borpeta districts have been extended for a further period of 45 days.
Yes.
From 20/01/2023. Over already.
Last
Over.
Over.
Hello.
It was after completion of 45 days.
Yes.
That was extension of earlier office memorandum 21/2021.
Last one is 16.
That's why last one has been brought out.
Last one is already spent its force.
I don't deny the issue.
I am just indicating.
Yes, no, my lord, I am not saying as you before.
This is also 45, again 45 days.
Last one is for.
Mr. Biswas, learned counsel for the petitioner has asserted that the petitioner has submitted all the supporting documents in support of their application for registration of sale deed. Despite submission of all the supporting documents, the respondent number, the respondent number 3 and the respondent number 4 have not yet disposed of the application. And the petitioner, as an applicant citizen, at least has a right to know the reason as to why the petitioner's application for registration of his sale deed has not yet been disposed of. Para. Registration Act, the Registration Act 1908 has been amended by the Registration within bracket Assam Amendment Act 2009 in its application to the state of Assam by insertion of a new section, section 21A, which reads as under paragraph 5. Para. On going through the office memoranda dated so and so, dated so and so, and dated so and so, it transpires that the office, each of the office memorandum has a currency period of 45 days. Para. Para 3. It is the under section 21, under the proviso to section 21A of the Registration Act 1908. Which is with a non-obstanda clause. No testamentary instrument relating to immovable property shall be accepted for registration, unless the Deputy Commissioner of the concerned district issues a no objection certificate containing the description of such immovable property to be transferred. And also such other no objection certificate, which are required to be issued by the Deputy Commissioner or any other authority under any law for the time being enforced or under any executive instruction, order, etc., issued by the state government from time to time. So in the case in hand, it appears, it transpires that the Deputy Commissioner has already issued a no objection certificate for sale or transfer of the subject plot on 25/6/2024.
Yes, 24.
And similarly, the Jurisdictional Development Authority has issued a no objection certificate for sale and transfer of a subject plot on
8/8/24.
under the provisions of the Assam Plan and Country Planning Act. Full stop. Para. It is a settled proposition of law that public authorities cannot play loose, fast and loose with the powers vested in them and the persons to whose detriment orders are made, are orders are to be made, are entitled to know with exactness and precision what they are expected to do or forbid from doing, and exactly what authority, under what authority the application is kept pending. Full stop. Section 21 proviso 2. It is the providing the service of registration or sale deed is a notified public service. Notified public service under the Assam Right to Public Services Act 2012, as amended. Full stop. And as per section Section 7 of the Assam Public Services Act 2012 is quoted here in order for ready reference. Reverting back to the facts of the case in hand, it is noticed that the petitioner has made the application online for the notified public service before the designated public servant on 3/10/2024. And while acknowledging the application, the designated public servant had observed that the service would be provided within a period of 1 day. And in the event the service is not delivered within a period of 1 day, the applicant can raise an appeal. Full stop. Since 3/10/2024, more than a period of 3 days have 3 months. 3/10, 5 months. 5 months.
Yes.
5 months have elapsed. Full stop. The designated public servant under the provisions of subsection 2 of section 7 of the Assam Right to Public Services Act has definitely has the power, has to provide the notified public service or else, reject the application. And in case of rejection of application, he shall have to record the reasons in writing and communicate to the person making the application. 1, 2, 3. The statutory provision has not given any, has not provided, is silent as regards the power of the designated public servant to keep an application pending more than the period stipulated for either allowing the application or rejecting the application. In such view of the matter, this court, this petition is disposed of with a direction to the designated public servant, within brackets, I don't know who is the one, the respondent number 3 and stroke or the respondent number 4, to pass a speaking order in terms of the provisions of section 7 of the Assam Right to Public Services Act 2012 as amended, recording the regions either allowing the application or rejecting the application, recording his reasons for such rejection. And the order so passed shall immediately be communicated to the petitioner applicant forthwith thereafter, besides uploading it in the portal. With the above observations and direction, the petition is disposed of. I think we are not into legality of the office memorandum.
Only thing,
Next
while
item is
recording my
your-
submission, Lordship, kindly record one thing, my lord. Because of the, my lord, position, my lord, the district authority is not in a position to proceed further.
Okay, because of the
While recording my submission.
reasons recorded in the office memorandum, the application with regard to application for registration of sale deed submitted for registration of sale deed in respect of the areas covered by the office memorandum, have not yet been disposed of.
Next item is your same matter, only medical ground here. Borpata.
They have cited various grounds.
Okay. Correction. Same thing?
Yes, yes.
Development authority?
Yes, yes.
Is it there?
Borpata.
Borbeta?
Yes.
And application made?
Yes, everything is same, my lord.
Same?
Same.
Okay, same যদি ঠিক আছে even date বোৰ অলপ 310 same thing বাকি এটা পেৰা সেই region for seeking.
Dates are little different.
Okay.
Public.
Typing method, item number 33.
You are the counsel.
Mr. Aramdas is the counsel. He is not in the court today.
You can,
I can communicate with you.
you take instruction from the respondent number 2 then. Okay, hired Miss R. Chaudhary, learned counsel for the petitioner. Social justice 1, who is 1? Okay, Mr. C. Sharma, learned counsel representing Mr. R.M. Das, learned standing counsel, Social Justice and Empowerment Department for the respondent number 1 and 2. And Mr. B.J. Taludar, learned senior counsel. Assisted by Mr. P.K. Medhi, learned counsel for the respondent number 3. Who has filed the affidavit?
Respondent number 3, Lordship.
Okay. The respondent number 3 has already filed an affidavit in opposition. And the petitioner has also filed an affidavit in reply to the said affidavit in opposition, full stop. To consider the issue raised in this petition, and affidavit, a counter affidavit on behalf of the respondent number 1 and 2 is necessary. Full stop. Mr. Sharma, learned counsel representing Mr. Das, learned standing counsel so-and-so has paid for and is granted 3 weeks' time to file a counter affidavit on behalf of the respondent number 1 and 2. Full stop. List the case on after view. So-and-so did. The respondent number 1 and 2 shall ensure that the counter affidavit is filed on or before the respondent next date of listing.
28-4. Item 36.
Please, your lordship.
Similar matter to be disposed of in similar
36 was when it
order.
They have not filed their affidavits.
This is an order by GMDA, no, GMC. GMC.
for the instruction, my lord. Because
Okay.
in the meantime, they have filed an application for regulation of the deviation.
Okay, Mr. M.
K. Jain.
K. Jain, Mr. K. Jain, learning counsel for the petitioner, and Mr. S. Bora, learning standing counsel, GMC, GMD for the respond number 1 and 2, and Miss M. Sahu, learning counsel for the respond number 3. Post of Mr. Bora, learning standing counsel, GMC stroke GMDA, has submitted that he has not yet received the necessary instruction to file counter affidavit on behalf of the respond number 1 and 2, and has prayed for how much? 2 weeks time, 3 weeks time, then next Bihu, 3 weeks time to obtain the necessary instruction and to file counter affidavit. The prayer is allowed. Prayer made by Mr. Bora is allowed. Lays the case after 3 weeks. The interim order passed earlier shall continue till the next date of list.
Much obliged.
The respondent number 3 may also file its counter affidavit in the meantime.
Much obliged.
Items 37 and 38.
Sell. 30?
37 and 48.
Okay. Yes. B. Sinha, petitioners. Revenue? No. PR Mohanto.
PR Montolo.
Revenue. J. Hendik, Engineering Government for the respondent to entry. Mr. Hendik has sought for and is granted. How much? 3 weeks? 4 weeks? 4 weeks time. What? All those Mirazdar or what?
Yes.
I don't know what is Mirazdar. Grant has paid for and is granted 4 weeks time to file counter affidavit on behalf of the state respondents. Lays the case after 4 weeks.
Yes.
Same thing. 38. No, দুইটা একেলগে দিলো।
Both are same.
Both are same.
39.
Lordship, here,
My lord, the earlier orders been seen, my lord. Because they are,
we were supposed to file affidavit by today. Lordship, we have sent it for waiting. We'll be receiving it either today or tomorrow. Lordship may take it up on Friday or Monday. Lordship.
Okay, Friday is reasonable enough. Monday, if they are saying that affidavit is ready.
Yes.
Okay. GN Sahal, senior counsel, estate by Ms. K. Sharma.
K. Bhattacharya.
K. Bhattacharya, learned counsel for the petitioner. P. Chaudhary,
For PWD.
standing counsel PW 1, 2, 3. J. Hendik, junior government advocate, Assam for the respondent 4 and 5. Full stop. Mr. Chaudhary, standing counsel PW, has submitted that he has received the necessary instruction to file the counter affidavit. And the counter affidavit has already been prepared and sent for vetting. He has thus sought listing of the case on Monday. Full stop. Holiday. Tuesday then?
yes.
Tuesday. 1st April. Okay, Tuesday. Para. The observation made in paragraph 9 of the previous order dated 24/2/2025 stands reiterated as regards the prayer for interim relief. If you don't file,
Yes.
Item number 40.
Please, Your Lordship, as per the last order, the respondent authorities were directed to file affidavit in opposition.
yes, Mr. Nayak was supposed to. Where is Mr. Nayak? Yes, he has come.
Inspection received, Lordship.
Okay.
On last day, Lordship opined that in this form, this petition is not entertainable because.
If file, then we'll decide because that day we did not decide.
I was thinking that he will impede the other sub.
That is up to them. We cannot. We may thereafter dismiss on non-joinder or not the locus, does not have the locus. We'll decide thereafter.
Yes.
You file your affidavit.
Lordship, since the commercial shops are closed since 13th December.
Mr. I have indicated my
Yes, the locus time very
tentative
point.
view
Yes, the
on the locus
That's
to
right.
Mr. Roy. So today or maybe after tomorrow, maybe after next date, we may decide the fate. Miss
Date may be fixed.
Miss
V. Rai.
B. Rai, Learned Counsel for the petitioner, and Mr. P. Nayak, Learned Standing Counsel GMC, for all the respondents. Mr. Nayak has submitted that he has received the necessary instruction and the counter affidavit on behalf of the respondent GMC authorities will be filed within 2 weeks time. He has thus sought for listing of the case after 2 weeks. Let me complete the order. Why you interfere in between? The prayer made by Mr. Nayak is allowed. List the case on so and so date.
Item 41.
Petitioner, Mr.
R. Besbura.
No affidavit till date. Wrong hand. After vacation. Mr. Sharma,
I am representing 7 and 8 Oil India. The thing is that between the money transaction, we have paid the money for now for exclude of the oil. Now they are just to
show them that you have paid the money.
only that is the part. The money is deposited whether he is entitled. Simple question. Last occasion court asked by the order whether they are entitled, then they disburse the money. That is only that. But that is for they now delaying the process. Or unnecessary, whatever, if the matter is delayed, we have to pay the penalty. All these things will come up unnecessary burden.
Where,
So
Mr.
very
No
simple
interim
last
order has
occasion.
been passed. What?
Yes.
What?
It was clear on last occasion was. Just in the last, the learned standing counsel to KSC authorities shall obtain instruction as regards the claims of the petitioner in respect of the areas of the land mentioned in the paragraph 6 of the writ petition on or before the returnable. Simple question was asked by the court. If they have instruction, so at least a date kindly be fixed.
What to do?
A date kindly be
We
fixed.
cannot go on fixing dates.
That is on the problem now, unless it is.
Mr.
R. Besbura.
R. Besbura petitioner as Mr. R. Ronghang, Learned Standing as the KAC for 1 to 6. B. Sharma, Learned Counsel for 7 and 8.
Yes.
Mr. Ronghang has paid for further 4 weeks time to obtain the necessary instructions. Most of the prayer is allowed, is the case after 4 weeks. And date to be fixed by the.
That is my humble prayer, Lordship.
This is 25,
After giving the date, we can-
25 matters. List the case in June. Give it in.
9 June.
Satisfied?
No, Lordship, that is only the
Then
thing was humble.
after
submission to
4
that.
weeks.
Lordship fix the matter, that's why Lordship. Any date of
Item
May,
42.
Lordship.
2025 matters. This is a matter of 2025.
That won't, Lordship.
We are struggling with matters of 2022 also.
Yes, Lordship, Lordship. Well, Lordship, sir, fix the date last occasion, just to take.
When
this
I
up.
said I do not,
No, Lordship,
I'm not inclined to fix any order,
that is my humble submission, Lordship, kindly.
or I'll say that otherwise I'll record. You may prefer an appeal. That fixation of an fixed date and court is declined, you may prefer an appeal thereafter.
Don't whatever decide.
Don't insist.
42.
This is the second date only, first returnable date.
I'm not pressing hard, Lordship. Just a very-
No,
very-
the manner in
That's
which
what-
you have pressed,
After 4 weeks, then Lordship, just only just.
the manner in which you have pressed.
Not pressing.
Item 42, I need some time. That communication to me, they need some time.
Which one?
42.
My lord, regarding the investigation by CBI for organized crime on the landscape, my lord, and for protection to life and property, my lord, they were supposed to file affidavit, my lord, on last order.
Yes, I get allotted for the petitioner, Mr. J. Hendik. 1 to 5. How much time?
After vacation.
Okay. Mr. Hendik has prayed for and is granted 4 weeks time to obtain the necessary instruction and to file counter affidavits. Lays the case on.
Second week.
After vacation.
Supplementary list, item number 57.
This is regarding the compensation. That chart, we have already placed it before your lordship. this serial number 5, he got that amount, Lordship. And from the writ petition, it reflects, it transpires that the average rate that he is not satisfied with the amount. In that case, he will go to the arbitrator.
Arbitrator.
Yes, madam. That direction may be given, madam.
Direction or only observation. Third, Mr. H.L. Oscar. Learned counsel for the petitioner. Any standing counsel? For AWD.
Lordship, I am appearing on behalf of Mrs. B.L. Singh, correspondently.
MS, Mr.
C. Agarwal.
C. Agarwal, learned counsel. Representing Ms. B.L. Singh. Learned standing counsel, PWD.
HID.
Huh?
Yes, man, number 3.
Oh.
3 and 6.
3 and 6. And Mr. H. Sharma. H.
4,
Sharma.
4, 5, 7, 8.
Huh? Where is your? Yes. Where is the notification?
Lordship, notification is.
Where is the project?
uh,
What is the project?
Project my lord, Bharatmala.
Name of the project. Okay. The central government in a Ministry of Road Transport and Highways had initiated a process of acquisition for a national highway project. Case 41, quote unquote, building within bracket widening 2-lane with paved soldier 4-laning, maintenance, management, operation of NH 37 in a stretch of land from kilometer so and so in the district of Kachar, Assam. The highway project was short with the issuance of a notification under
Annexure 7 is the notification. Page number 41.
which culminated, which under the provisions of the National Highways Act 1956. Full stop. The notification under subsection 2 thereafter any notification. Now, where is your award?
Award, my lord, page Annexure 7, page 41, my lord. Relevant, my lord.
In the process of acquisition, the petitioners a plot of land belonging to a petitioner measuring
Measuring, my lord, page number 46, my lord.
page number 46.
46, serial number 20, serial number 21, serial number 24.
Tell me anything, anywhere it is mentioned in the writ petition.
Yes, my lord.
Paragraph.
Paragraph, my lord.
The following area of land. This
Paragraph
table,
4, my lord.
table, this table.
Yes, my lord.
The following areas of land belonging to the petitioner and his siblings came to be acquired. A table of description to read you, huh? It is a case of the petitioner that the competent authority land acquisition, appointed under section 3 within bracket A of the National Highways Act, has already assessed the already determined the compensation amount under section 3G1 of the NH Act. First off, it is the grievance of the petitioner that the competent authority land acquisition, while determining a compensation amount for the plots of land belonging to the petitioner, has not taken the relevant factors in the proper perspective. First off, It is the further contention of the petitioner that the market value of the plots of land in question under acquisition were taken at a lower amount, resulting in an inadequate amount of compensation. First of para. Mr. Sharma and Mr. So-and-so, Learned Counsel appearing for the state respondents have submitted that by an order dated 6/3/2025, an arbitrator under section 3G5 of the NH Act 1956 has already been appointed for deciding any application in respect of the highway project in question. And since the petitioner's grievance is limited to inadequate amount of compensation, the arbitrator so appointed can decide an application preferred by the petitioner for enhancement of the compensation amount, if such an application is preferred. First, para 3, 4, 6, 7, 8. Okay, you prefer?
Yes, sir.
Dispose of.
Disposal.
Most.
But I am sorry to disturb at this hour.
Yes.
Item 38 supply, my lord. Your lordship wanted to know 58.
68.
Yes.
The lordship wanted to know, my lord, about as to whether the charge sheet is filed in the first FIR or not.
Yes,
That
50.
is why the additional public procedure. As we
yes.
was fine, lordship, he has not, I have not called him lordship. I think.
Okay,
Lordship has
put it on.
as per your
witness
lordship's
stand.
convenience.
Okay, so to get the information Thursday then. Thursday, we'll get the information from the PP. Okay, put it on as Bishwas H. Sharma. I got to Silva. Release the case on Thursday. And what are these or 45 and 46? 2015 matter. 45 and 46, 2015 matter.
2015. Your lordship, 45 will have to take fresh steps upon respondent number 4 with correct address.
Matter relates to bank auction.
Yes,
The
yes.
property under the DRT Act.
And who is the petitioner in item 45?
In item 45 is the Bimal Chandra.
And 46.
45 and
Kartik Sarkar.
Ah.
46.
Who is the petitioner?
Bimal Chandra Sarma.
Kartik Sarkar.
Yes, Kartik Sarkar.
That appears to be infructuous.
It appears, it is,
Infructuous. It is.
yes, sir.
Well, you were there. Okay, put it on some other day. We'll decide about 46
Yes,
that it is infructuous. Okay, Mr. S. Dr. Learned Counsel for the petitioner in 46. And Mr.
45.
M. Sharma, Learned Counsel for the
Lordship in 45, I mean. For the
45.
petitioner.
Okay,
Yes, sir,
petition.
7360.
And Mr. M. Sharma, Learned Counsel for the respondent, Central Bank of India.
Yes, sir.
Are in attendance to stop the Learned Counsel for the petitioner in 46 is found absent today on call. To stop, let the cases be listed again on Friday. Will not open the file.
Okay.
Lordship, item number 52. On last occasion, your lordship wanted to know from the Cooperation Department advocate whether my house is further required. It is sealed, lordship. I am unnecessary.
Instructions are awaited. Next Wednesday. Mr.
I am R. Islam.
R. Islam, Learned Counsel for the petitioner is present. Mr. Goswami, RB. Goswami, Learned Counsel representing Ms. M. D. Bora, Standing Counsel Cooperation Department, has submitted that he has not yet received the instructions regarding sealing or de-sealing of the first floor of the
house of the
building
of the petition.
belonging to the petition. He has thus sought listing of the case after we close the case on Wednesday.
Second April.
On third matter.
Third, not third, Thursday. For this matter,
Then be on fourth matter.
don't put it stretch it too much.
No, not stretching it, my lord. Absent next week.
I'll make you come on Saturday. Right? Since I am coming, I'll also make you come. Huh? Saturday? No. Take it. 2nd of April. 2nd?
Fifth, my lord.
Fifth.
Fourth.
4th.
Ablash.
5th is, 5th is also open.
Everyone's fourth.